Good morning, everyone. As President of Victim Support Europe, I get the honour of welcoming you all to our 2021 Autumn Conference, which focuses on the topic, how to ensure safe justice from a victim's perspective. And it was in the interests of safety that the board took the decision last week to move this year's conference from a hybrid event to a fully online event. Whilst we were disappointed not to be able to welcome you to the beautiful Château de Lac in Brussels, the health and well-being of us all was our top priority. And we trust that we are still able to engage in a meaningful and constructive way via this online event. It would be remiss of me not to pay particular tribute at this point to our Victim Support Europe staff, whose professionalism, dedication and agility has enabled us to very quickly adapt to this online environment. On behalf of the board, I would like to thank each of you, and in particular Marina, who has led on this workstream. Now turning our attention to today's event. We have a diverse group of experts gathered today online, who all have a single shared goal: to start a meaningful conversation on how we can make the criminal justice system work in a way that is less harmful to victims and their families. In late 2019, Victim Support Europe embarked on a new initiative to draft a paper on the topic, how to ensure safe justice from a victim's perspective. This paper will outline the problems and barriers encountered by an actual victim during their journey to achieve justice, from the moment the crime is committed to the outcome of the criminal proceedings. The paper will challenge ideological concerns and preconceived notions that form the basis of current justice systems and may influence the victim's ability to achieve safe justice. Using this theme as a starting point, today's conference will provide an opportunity to showcase a wide variety of projects, initiatives, and programs that can be adopted by our criminal justice systems. We will begin today with a welcome and opening speech from the European Commissioner for Justice and the Acting Director of Criminal Justice, before hearing from a survivor of crime who will set in context the issues we are planning to address through this work. We will then turn our attention to how we can ensure a safe and supported reporting process for victims of crime, and also examine the barriers they need to overcome. We will then move to explore the structural development of victim-centred criminal justice, looking at legislation, multi-agency cooperation, effective communication and information sharing, as well as examining the training needs of our European judiciary on safe justice. Our final live debate will explore the question of what can be done to make the criminal justice system more victim-centric. I thank you all again for joining us online. I sincerely hope that you will enjoy today's programme of debate and knowledge exchange, and I thank you in advance for your participation. Now, I would like to hand over to Victim Support Europe's Executive Director, Levent Alten, who will moderate today's event. Thank you.
Thank you very much, Jerry, and good morning, everyone, or good evening, good afternoon if you're outside of Europe. So as Jerry said, I'm Levent, I'm the Executive Director of Victim Support Europe, and it's my pleasure today to be the moderator for this year's conference. As Jerry said, we're very regretful that we couldn't hold the conference live in Belgium, but that's the way things work at the moment. Nevertheless, we've got a really interesting, exciting agenda, which I'm really looking forward to. So what we're going to be doing today is 3 different sessions, as Jerry just explained, looking at the state of practice of the criminal justice system, really looking at how it works, what are the best practices, what are some of the problems. I'll be chairing the whole process. And so to start with, I'll just go through the normal housekeeping rules. So as we always say, and I think everyone's used to this, for speakers, could you please make sure that you mute your microphone when you're not speaking? For all conference participants, just so you know, we have a chat box area for you to ask questions. We've organized the event in a way that actually you'll be able to ask questions, and speakers will be around for around 30 minutes after their presentations, and they'll be able to address any questions within the chat box. So we won't be taking live oral questions. And of course, when we're online, it's really difficult getting that sense of connection with each other. We do have nowadays, thanks to Zoom, we have the applause button, the thumbs up button. Please let speakers know. It's very difficult when we all give these speeches and we don't know how people react or feel about it. We don't have that same sense of eye contact. So please let people know how you feel, what you thought. Put comments in the chat box as well. To keep to the schedule, Leah will kindly be keeping a track of the timing. And I know it always sounds a little bit rude, but around the 5-minute mark and 1-minute mark, speakers will be informed. And we always try to get in between those sentences so we don't cut people off. It's just to keep everything on track as much as possible. So those are the main housekeeping rules. So rather than keep on chatting, I'm going to now hand over to our first speaker, which is European Commissioner for Justice, Mr. Didier Reynders. Over to the recording.
Ladies and gentlemen, thank you for your invitation and the occasion to address you today. It is a pleasure to open this year's Victim Support Europe's annual Autumn Conference. Any one of us can become a victim of crime. For victims and the affected families, it is always a traumatic and difficult experience, no matter what the crime is. Over the past years, we have made it a priority in the European Commission to protect the rights of victims. We have already achieved a lot. Since 2012, we have in place the Victims' Rights Directive, a solid set of EU rules that provide for binding rights for all victims of all crimes. Under the Victims' Rights Directive, all victims of crime have the right to access information, to support and protection according to their needs, and to a set of procedural rights. Then, in June last year, the Commission adopted its first ever European strategy on victims' rights for 5 years. The strategy sets out concrete actions to ensure that all victims of crime, no matter where in the EU or the circumstances of the crime, can fully rely on their rights. It frames our work until 2025 and invites other actors, including EU member states and civil society, to take action. I'm very happy with the progress the Commission has made, but the work on implementing the EU strategy on victims' rights will not stop. Safe justice for victims is a very important part of this strategy. We cannot undo the crime, but we can work together to ensure that victims feel safe to report crime and participate in criminal proceedings. And they should be able to claim compensation and ultimately recover from the effects of crime as far as possible. For the most vulnerable victims, it is particularly challenging to go through criminal proceedings and to cope after a crime. For them, it can also be very difficult to report crime. Crime underreporting is, in general, a serious problem. A key priority in the strategy then is effective communication with victims and a safe environment for victims to report crime. Too often, victims are not aware of their rights, or persons in contact with victims who should inform them of their rights don't have sufficient training. Raising awareness about victims' rights is a vital element of creating a safer environment for victims. So, next year, the Commission will launch an EU campaign to raise awareness about victims' rights. In this context, we will also promote specialist support and protection for victims with specific needs. Also, cooperating with victims' associations and with experts is crucial for properly implementing our strategy. In addition, We are currently evaluating the Victim Rights Directive. As the directive entered into application more than 5 years ago, it is time to verify whether it is fit for purpose. We will publish a report on the evaluation of the Victim Rights Directive at the start of next year. On the basis of the evaluation report, we will assess what other actions are necessary to ensure that all victims of crime can fully rely on their rights. And we will propose a revision of the Victim Rights Directive by the end of 2022. We will also propose new rules relating to the protection of victims of violence against women and domestic violence, and on hate speech and hate crime. And my team will coordinate all these initiatives to ensure full coherence between them. As you can see, we have a lot of work ahead of us, but I'm confident that it will result in more victims of crime benefiting fully from their rights. Our goal is to leave no victim behind and unprotected. I take this opportunity to thank Victim Support Europe and all of you for your strong commitment for victims' rights. And I wish you a fruitful conference.
Thank you to Commissioner Reinders for that introduction. And I think it's really important to keep in mind that the European Commission has been a constant champion for victims, at least over the last 2 decades, starting with the 2001 framework decision. They've worked very closely with Victim Support Europe, with the other victim support organizations. The progress that they've made, the decisions to establish a strategy, to establish a European coordinator for victims, all new innovations, I think really shows leadership in where we need to go in terms of a coordinated system for victims and for implementing victims' rights. So thank you to Commissioner Reinders for that introduction. We're now going to hear from Mr. Richard Sonnenstein, who is the Acting Director of Criminal Justice in the European Commission. And I think he will go into a little bit more detail about the plans in DG Justice and in the European Commission. So I hand the floor now to Mr. Sonnenstein.
Thank you, Levent. Good morning, everybody. I hope you can hear me properly. Good.
Yes, we can.
Dear Ms. Hanna and dear ladies and gentlemen, first I would like to thank you for your kind invitation to speak on today's conference. You just heard the Commissioner, so I cannot reinvent the wheel, so forgive me if here and there I will have to repeat what he said, but indeed I try to complement as much as possible. Of course, I would have preferred to meet all of you at Chateau de Jeanval, which I know very well, but okay, the world is as it is. So Commissioner Reinders already provided you with the bigger picture of our policy in the area of victim rights. I was asked to focus a bit more on the topic of safe justice for victims, which I will happily do. Let me start with the question. So why is safe reporting of crime important in this context? Because it's the foundation actually towards achieving safe justice for victims. We must help victims to overcome the fear of reporting crime due to their fear of being victimized once more when participating in criminal proceedings. We know that no one wants to force victims to report crime, but instead the focus must be on creating a safe environment for them to do so. It is important that if a victim reports a crime, that there will be a proper follow-up, that the victims are treated with respect and dignity by everyone who comes into contact with them, namely by the police, the judiciary, and by support services. This is also acknowledged in the EU strategy on victim rights. Commissioner Reinders just mentioned it. We are very intensively working currently on the implementation of the strategy. In the strategy, we propose a set of actions which shall contribute to create a safer environment for victims to report a crime. This includes, firstly, rising awareness on victim rights at the EU, but also at national level. Secondly, it comprises providing for EU funding to national victim support organizations and to relevant community-based organizations. Via the 2014 to 2019 annual work program, we awarded 13.2 million euro to almost 50 projects aiming at, for example, capacity building for professionals, multi-disciplinary cooperation, exchanges of good practices, dissemination, and awareness raising on victim rights. So we count actually on your expertise to come up with good projects. You are close to the victims. You know best what type of support is needed. At the end, we will all be held accountable for what actually arrives at the level of the individual victim. Furthermore, at the national level, we need a better cooperation and coordination of all persons that come into contact with victims. At the EU level, we also need to involve different institutions, different bodies and civil societies to ensure synergies of our actions. We do that already within the Victim Rights Platform, which you know, of course, very well, that was established under the strategy. The meetings of the platform provide a place for the main EU-level actors to discuss and brainstorm on major actions under the strategy. As a result, we can already identify a few cross-cutting themes that are also relevant for safe justice. One is the need to strengthen the so-called multi-agency approach. You can also call it a multi-layer approach to victim support. This concept requires close cooperation among national authorities, victim support services, and the relevant communities. Another theme which comes up not only in this context, all over actually in criminal justice, is the importance of training. This applies again to all practitioners at all levels which are in contact with victims. It includes the police, the judicial authorities, but also prison staff. So what are the next steps? We are currently in the preparatory phase for the EU awareness raising campaign on victim rights. The main two objectives of the campaign are A, to focus on raising awareness about victim rights in general, and B, to promote specialist support and protection for victims with specific needs. Here I'm referring to those victims who are the most difficult to reach, including children, persons with disabilities, and victims of domestic violence. Particular attention will be paid to the appropriate methods of communication so that the campaign reaches the target audience. In the first quarter of 2022, the Commission will present the results of the evaluation of the Victim Rights Directive in a so-called staff working document. For those of you who work often with the Commission, know already that model. The evaluation will analyze the need for further steps, be it of legislative or of non-legislative nature. Aim is to improve the rights of victims of crime. In parallel, we are also conducting preparatory actions for so-called impact assessment of the amendment of the EU rules on victim rights. A call for evidence will be published soon on the Commission's website for 4 weeks to gather input from stakeholders for this impact assessment. So at the beginning of next year, it will be followed by an open public consultation. It's a questionnaire actually asking for your input also on possible actions so that all victims of crime are able to fully rely on their rights. So I take this opportunity to invite you all to take part in this consultation. It's very important for us. We need this input so that you are able to share with us your valuable contributions. We need your input on this, and it's also important that we continue working together, as it was in the past, to enhance the experience of victims in the criminal justice system. That's all I wanted to say. I wish you, of course, a very successful conference. I will stay with you for a little bit longer, but I have to leave at a later stage. Thank you very much.
Thank you, Mr. Sonnenstein. And I think the points you raise are extremely important. Some of these issues around awareness raising, multi-agency approaches, the training that's needed to make sure that we don't just have rights, but those rights are implemented and put into practice are absolutely fundamental. And the funding we see has been so critical that's been provided. And I see I wonder, have you been working with other parts of the Commission beyond DG Justice to see how funding can be incorporated into other areas? We see, for example, Horizon Europe includes more on victims. Is that something you've seen as you've been working with other DGs?
Well, when we actually prepare our proposals, we work, of course, with all services. You mentioned, for example, also DG Home, especially when it comes to specific areas, like victims of terrorism, etc., etc. We are leaving a bit our home grounds, and we have to reach out to the other services. So indeed, we work together with a whole series of other departments. Also on the training area, for example, we are also always reserving a slot in funds which actually are managed by other DGs, indeed. I think you have to activate your micro.
Thank you.
Unmute.
I muted rather than unmuted, sorry about that. But we also have a speaker from the European Police Academy and from the European Judicial Training Network. So we'll hear a little bit about training as well. So thank you, Mr. Sonnenstein, for that. And we will now move on. I think we have a lot to think about for next year, many opportunities to inform the Commission. We have to be active. There's no guarantee that the directive will be updated, and if you think it needs to be improved, that changes need to be made, we all have to speak up and say what exactly is needed. So thank you for that opening speech. We'll now move on, and I have the absolute pleasure to welcome an extremely courageous lady. For those of you who know Victim Support Europe, you know that it's important for us to hear directly from victims and survivors, to give them a voice, but to hear directly about their experiences. And we'll now hear from Nina Fuchs, who is a survivor of sexual assault and who will be speaking about her experiences of the criminal justice process in her country. So Nina, thank you very much for your willingness to speak today and share with us your story. The floor is yours. Thank you.
Thank you very much, Levent. Hello, everyone. As Levent said, my name is Nina. I'm from Germany and I'm a survivor of sexual violence. I'm a bit nervous because normally I don't do this in English and not in such a context, so please excuse my nervousness. I would like to start by telling my story, which starts in April 2013. When I was out with friends in a club in Munich, and my drink got spiked. I have a 1.5 or 2 hour blackout, and the moment when I regained a bit parts of my consciousness, I was in the middle of a rape. There were 2 men I've never seen before in my life, and one of them raped me. The next day, my sister took me to the police, which unfortunately was a very traumatizing experience for me, because the police didn't believe me, but I will talk about that in a bit more detail later. The forensic doctors who examined me roughly 12 hours after the incident could unfortunately not find any traces of the rape drugs because it was just too late. They can only be detected for a very short time. But they could find traces of a DNA of one of the perpetrators. I got massive support by the German victim support organization Weißer Ring. They provided a lawyer for me for free, and this lawyer has been with me for many, many years and supported me, and I'm extremely grateful for that. Due to this situation, I could also appear as a joint plaintiff and got access to the files and all the information. In February 2014, 10 months later, the case got closed because there was no match in the database with the DNA. from 2016 on, I started with something like advocacy work because I found out that there was a general lack of knowledge regarding the topic of rape drugs. 2 years later, in May 2018, I received a letter from the prosecution that they had a match in database and that they had found the alleged perpetrator. So my case was reopened and further investigation was done. I was full of hope at that stage because due to the DNA, for me, it was very clear that the person they have found was indeed the perpetrator. Unfortunately, on the 2nd of January in 2019, I received a call by the prosecutor telling me she didn't see a chance for conviction and will close the case. Her reason for that was, for me, something I could not really handle very well. I will quote what she wrote in her letter. The DNA traces are indeed proof that physical contact between the victim and the suspect took place. However, since the victim cannot remember long periods of the night of the crime, it cannot be proven that the suspect is actually one of the two perpetrators. In particular, one cannot be sure that the victim had sexual contact with other men during the night of the crime. Under these circumstances, the suspect is more likely to be acquitted than convicted. There are therefore no grounds for filing a lawsuit. So even though they acknowledged that I was, due to the blackout, not in a state where I could defend myself, and there was the evidence of the DNA, the case was closed and I never got a fair trial. My lawyer saw the situation very different. He saw a chance for a conviction. So he filed a complaint. For that, he needed my file and all the documents. And what was very weird was that the prosecutor had actually removed 5 pages out of this file to create a separate volume just out of 5 pages. And when my lawyer finally received those 5 pages, it was it contained the report by the forensic doctor in which, among other things, typical rape injuries on my upper arms were documented. So a weird way to handle that, in my opinion. So I felt really treated not fair. And I started a petition because I knew that filing a complaint is not has not very high chances to be successful. So my petition was very successful. Until today, more than 110,000 people have signed it. So with that petition, both my journey as an activist and my journey through the German justice system started. Due to the success of the petition, there was also a lot of interest in the media, and so I talked openly about my case in a lot of TV programs, and I got contacted by a lot of other survivors of sexual violence. So what I learned in that was that my story is actually not just a very tragic individual case, but it's the standard. And I heard many stories where, compared to that, mine is actually a very pleasant story. So I'm here now talking to you just by myself, but actually I'm representing many, many cases and many, many stories and voices. This is also shown if you look into the statistics in Germany. Like in every country, we have very high number of unreported cases. This is roughly in Germany 85%. So from the 15% left, only 7.5% are convicted. So this means that if you have 100 cases of rape, it will lead to approximately 1 conviction. So this is very sad, actually. So to come to my journey through the justice system in Germany. In the end, the complaint my lawyer filed was rejected by the Attorney General's office. So the next step you can do is called enforcement proceedings, which has barely a chance of succeeding. It's roughly 2 to 5% chance. I still did that, but it also got rejected by the higher regional court. So in last year, in July, I filed with a lawyer a complaint to Germany's Federal Constitutional Court, which is the highest level I can go to in Germany with my situation, where I want to fight for just receiving a fair trial, and it's denied. With the Federal Constitutional Court, there was actually 0 chance in succeeding, but it was my only way to get to the European Court of Human Rights, which is actually right now the case, because as expected, the Federal Constitutional Court rejected my complaint, and that was 1 year ago in December last year. So right now, my case is at the European Court of Human Rights in Strasbourg, and I'm waiting to hear from them. So I'm fighting now almost 3 years, and this fight has cost me a lot of strength, time, and energy. It is not an easy fight, but on top of that, it has also cost 22,000 euros just for costs and lawyers. Luckily, I didn't have to pay that myself. I was able to finance that through crowdfundings, where I had many people who supported me with that, and I'm incredibly grateful for that. I could not have paid for that myself. So the question is, why am I doing that with all those levels where I already know in advance that I have 0 chance, or almost 0 chance? So already at that time in 2019, I knew that I wanted to found an organization to fight for victims of sexual violence, and that their voices get heard. So I encourage victims to report and to fight for their rights if they have the capacities. So for me, it is very important to actually walk the talk. So to be an example and do the things that I preach. And also, every case is a reference for another case. So I fought really hard to change something. But in the end, every level confirmed the decision the prosecution made, which in my point of view is just a free pass for every perpetrator. Because if you say we close the case because the victim has a lack of memory, I think this is really damaging to get this message out. So this is why I kept continue fighting, even though I didn't really have the chance to succeed. Since I've never been inside a courtroom, I wanted to tell a quick story of another survivor of sexual violence. It was a very young woman, and she was also drugged and raped by 2 men who came from very rich families and had a lot of money to pay for 4 very excellent lawyers. In the courtroom, those lawyers made the court watch the victim the whole video of her rape, which she didn't remember because she had a total loss of memory. The court said yes to that. The judge responsible agreed that this victim had to watch her own rape on video from the beginning to the end. She said it was like going through hell, actually worse than hell. So in Germany, the definition of rape is at the moment, after we had a change in the law 2016, no means no. So you either have to defend yourself physically or say clearly no. So the problem is that there is an absence of consent in our law. And this is problematic, which is also something that Amnesty International in their report, Right to be Free from Rape, published in November 2018, agrees. So I would like to quote. The amended legislation, however, does not focus on the absence of consent as such, but on the victim's expression of their refusal to engage in the sexual act. The no means no model is problematic as it implies the existence of consent by default in every situation where there is no express refusal to engage in a sexual act, as opposed to interpreting consent as active participation and or affirmative expression. According to this model, women consent to sex perpetually unless they state otherwise. And in other words, if you're passive and cannot say no for whatever reason, and there are many, this can be seen as consent within our law. And a study from Sweden shows that 70% of people in a situation where they don't want to have sexual action are in a state of shock or what's called tonic immobility, so they just cannot say no. For this, we started a petition to change the German law and get this aspect of consent and only yes means yes into our law. I said I wanted to talk about the police. And I know that I'm running massively out of time, but I was told because I'm a survivor and I can go a bit over time. I mentioned before that my experience with the police was very traumatizing, and sadly I have to say it was more traumatizing than the rape itself. So I was told, this is a very common expression in German, and I heard that throughout my childhood, police is your friend and your assistant. And I experienced the exact opposite when I came there in the worst situation of my whole life. So even though there was zero indication that I was lying, they still didn't believe me. And they told me literally, this thing with the rape drugs doesn't really exist. It's just a media hype. So there has been done research that showed that a lot of people who work for the police believe rape myths, and this is connected to the credibility of the victim. So if something doesn't match with their view of how a proper rape should work, then it leads to the fact that they don't believe the victim. And this is a very big issue. The biggest issues I see in general is that on all levels, police, prosecutors, judges, they are not educated and trained on the topic of trauma. And this is really an issue, because how are they even able to be competent to do their job if they don't have information on the most important thing which they need to make their decisions? Because a traumatized person reacts very differently to a non-traumatized person. And this is also something that is not taken into account in the deadlines and periods you have. 2 examples. After the suspension of your case, you have 2 weeks to file a complaint. If you are traumatized and suffering from PTSD, it is very hard to make this decision in 2 weeks. It is impossible almost, because you have to deal with the emotions and everything first. And the second is, after your enforcement proceedings are rejected, you have 1 month to file a complaint with Germany's Federal Constitutional Court. This is exactly the time the lawyer needs to file that complaint, because it's a very complex thing. In my case, I was drained emotionally so heavily that it took me 2 weeks to make that decision if I want to fight further or not. This complaint cost 10,000 euros, and I knew there is 0 chance of winning. It was a very hard decision, and it was not easily made. So in the end, my lawyer had only like a week or 10 days to do that complaint, which he normally needed 1 month. So this also leads then to lower quality, obviously, if he hasn't that time. Then another problem is that we have a massive gap between offender protection and victim protection in Germany. If you look on the side of the victim, there are no protocols for police interrogation like it's with kids, that it has to be taped on video. So every time the victim has to reproduce everything. This also leads to the fact that they are not allowed to do trauma therapy before there is a trial at court, because this could affect their memory. So they are prevented from healing, actively prevented from healing by not being allowed to do trauma therapy. This cases often takes ages. There is one famous case in Germany right now by Gianni Temple. It's our most famous Me Too case against director called Wedel, and she's been waiting for 3 years that the case will be opened in court. So this is very torturous, and often victims have to undergo a credibility assessment, which is also a very torturous hour-long procedure. On the other hand, the offender, there is no credibility assessment. The offender is allowed to lie. This is in our law. And if it takes long, this is actually an advantage for the victim, because the more time has passed, the lower will be the sentence. So this is not really fair. So to sum it up, what we need, in my opinion, is we need longer periods for the victims to react to certain decisions. Then also, as Mr. Sonnenstein just said before me in his speech, we definitely need more training and education on all levels in the justice system, at the police, especially on the topic of trauma. And in general, we definitely need more victim protection and empathy for victims. And of course, we need only yes means yes in our law. Thank you so much for your patience and letting me go way longer. I would like to thank Victim Support Europe for this invitation and giving me this platform to speak. I also want to thank VSE Ring for making me, bringing me into contact with Victim Support Europe and supporting me throughout all those years. I thank all of you for your attention, for your patience, for listening to me. And I thank everyone who is supporting my NGO and my work and my fight for a better world for victims of sexual violence. And also, like Mr. Sonnenstein, I will stay here for a while and answer all your questions. Thank you.
Thank you so much, Nina. You won't have seen the comments, but there are many comments which are expressing their real appreciation for your courage, not only to speak today, but also to really stand up for victims, to be their voice, knowing how little chance you have with your own case, yet willing to put forward your own money, your own energy. So I think that was an extremely powerful speech. I think, just to quote back, your experience with the police was more traumatizing than the rape. I think if you have people and victims saying that, you have a problem with your system, which is exactly what we have to resolve. And I think you brought across so many issues, which we'll discuss today, and I won't unpack those, but what it says is that we have to change our rules, our procedures, our behaviors. And when it comes to sexual violence cases, really it comes down to the fundamentals even of how you define certain crimes and how victims are recognized. And certainly we see movement in countries like Sweden, for example, where the concept and the definition of rape has been changed to recognize some of these difficulties. I think when we talk about rights and you say you have zero chance of success, that you have to question whether that's a genuine right in reality. So there's a lot for us to think about there. You've really set the scene very well for us. I'm sure we will stay in contact, and I really wish you every success in all of your work and in the proceedings as well. So thank you, Nina.
Thank you so much, Levent.
So we will continue now, and with that really important background, I just wanted to spend a few minutes setting the scene, really, for the next speakers. I won't spend too long. They gave me a whole 20 minutes to speak. I think that's because they know how much I love to speak, but I will not speak for 20 minutes before moving on to the next speaker. I just wanted to talk about safe justice and what is this concept of safe justice. And I suppose really picking up on some of the experiences of Nina, the question is, what do we consider to be success in justice? Is it enough that we find guilty people guilty and that we protect the innocent and that we're efficient in doing that? But, you know, when I first started working in this field in the European Commission, seconded from the Ministry of Justice, there was a case which really struck me and which has really inspired me to continue working in this field and really push some of these questions. And it's similar in many ways to Nina's experience. And it was about a young victim who was raped. She too was brave enough to report the crime and to go through the criminal proceedings. She actually had success in that justice system. The person was found guilty, but 2 weeks later she committed suicide. And in part, that was because of her treatment by the system. So is that a sufficient measure of justice to have found that person guilty? If not, then what do we need to do? What do we need to change? How should our justice systems be organized to reflect the needs of victims, to better protect them and to ensure better outcomes for them? And this is what Victim Support Europe really wants to discuss now. This is why we're preparing a discussion paper to examine these issues. This is why it's such an important period of time. The European Commission is looking at what should happen next. The Council of Europe is looking at what should happen next. So this isn't an agenda with no change in sight. We can really influence that agenda and ask some of the difficult questions and challenge fundamental assumptions about how our justice systems operate, such as what should the role of victims be in proceedings? Should all victims be allowed to be parties to proceedings? And are there some fundamental flaws in our adversarial or inquisitorial systems that need changing? And this all really starts from the moment a crime is committed. As we heard from the European Commission, it starts from the point of actually reporting the crime. We know many victims never even get that far. They never even report. But why? What are the challenges? What are the barriers to reporting? How can we make it easier for victims to come forward? Should we be providing them direct assistance? Should we be changing the technologies that are used to report a crime? How are we part of the problem as victim support workers or prosecutors or police officers? Do we discourage victims from reporting? And what happens when they come forward? How are they treated? What should we do to change that process? How do we work out what their needs are and ensure that those needs are addressed? How do we protect them within the processes that we've established? Are there innovations across Europe, across the world that we could incorporate? And rather than talking about best practices and projects, how do we establish common practices which are in line with the needs of victims? And this goes on through to the trials themselves and through to the post-trial phase. How do we ensure that victims are heard? How do we make sure that that there are remedies when victims' rights are not properly ensured? Do we even need to fundamentally rethink how we approach trials? And what would be the implications for our justice systems for fair trial rights, which are just as important as victims' rights? So what are these implications? What can we do? And how can we coordinate and work better to achieve it? So these are some of the fundamental questions that we're asking. Some of them we want to raise within our paper. Some of them we're going to be talking about today. And hopefully, as part of these discussions, we will see some changes, whether it's next year, in 5 years or 10 years. We know that crime is continuing. We know that there are many forms of crime which are actually increasing. We see an unstable environment. We have a pandemic. We have lots of instability across the world, which is influencing what crime is happening. So that we are not going away, victims are not going away. So we need to discuss these things and look at how our justice systems can be continually improved as we go forward. So this is where we are. This is why we have our conference today. Before we move on to the first speaker, what I'd like to do is just launch a quick poll. I know it's quite hard constantly listening to people, so we wanted to be a little bit interactive, not as much as if we were all together, I know, but maybe we can first launch the first poll now and just give people an opportunity to reply. So what you should see now is a question coming up on your screens for those who have registered to participate, and you'll be able to vote based on the question. So can we start the poll, please? There we have the poll. So what is the most common reason for not reporting a crime? What do you think is the most common reason? We have three there: fear of reprisal, lack of trust in the police, and perception that the crime is not serious enough to report. So what do you think are the most common reasons for not reporting? We'll give you a few seconds to reply. And maybe, do we have all responses yet? If we do, maybe you can show them. Or is there a lot of pondering? Okay, can we show the results? That did not work. Maybe we can try again.
Yes, we're trying right now.
Come on, Zoom, we can do this. I'm being told that people are unable to vote. Ah, there we go. Here we go. Look at that. Zoom has woken up. I like the fact we can see everything moving. This is exciting. Are we there? 100%? Okay. Wow, that's no. Oh. Okay. Tell me if we're finished. Maybe we can close the poll now. There we go. Okay, so we have there 42% think it's fear of reprisal. We've got 57% who believe it's a lack of trust in the people, and 42% believe it's perception about crime. We did a little bit of research beforehand. We went actually to the European Fundamental Rights Agency to see some of their survey work. And what they did in their Crime Safety and Victims' Rights Survey, but back in 2022, was asked this question. What they found was that 40% of respondents don't report the crime because they believed the crime was not serious enough to be reported. But on top of that, we had 28% who said they were better able to deal with the situation themselves without involving the police. 18% believed that the police wouldn't do anything. Another 18% mentioned other reasons. And then we get into other percentages. 11% were fearful of reprisals. 11% thought it was too much trouble. 9% didn't trust the police, and 4% reported to other authorities. So it's really a mixture there. I think what will be interesting is to start really breaking down some of these statistics and disaggregating it. When you look at certain groups of victims, I know the FRA have done research for gender-based violence, for hate crime victims, for migrant victims, for example. And there you see a real change in those percentages as well. And I think you see those changes the more serious the crime, and for certain types of crime, say like sexual violence, I think you see changes there. So that's really interesting to see these different percentages. We'll now move on to our next speaker, who is Ales João-Hanek. He serves as the hate crime officer in ODIHR's Tolerance and Non-Discrimination Department. And there he's responsible for hate crime monitoring, capacity building and policy work. And he was in charge of the compilation of ODIHR's annual hate crime reporting. So he has a huge amount of experience as a trainer for multiple diverse audiences. And so he will be speaking about those processes and the framework for facilitating reporting of hate crime and the situations of underreporting. So over to you, Ales.
Thank you very much, Levent, and thank you for having us. To answer the question, why should reporting a hate crime be a priority, I think that has been answered. Just like any other crime, and perhaps even more so, if hate crimes are not reported, they are not prosecuted. There's impunity for perpetrators, no justice for victims. Laws remain basically on the books but not applied, which weakens them obviously. And perhaps most importantly, in the context of this this conference, the victims also do not receive the support that they need. I would at the beginning I would maybe lay out three main reasons why hate crimes are different from other types of crimes. The first one is that the impact of hate crimes is deeper and is broader. Hate crime victims often describe deeper experiences with victimization, deeper trauma, different trauma. Sometimes research compares it with victims of sexual violence, understandably, because it's the identity of these victims that's being targeted. But the impact is also broader. There may be one victim only, which is a direct victim, but then that victim is targeted on account of their personal characteristics, which the victim shares with others in the same community, and that community is also affected. So the range of the indirect victims is quite broad. That's why also we call hate crimes message crimes. Sometimes through that one direct victim, they actually send a message of rejection to the whole community. And this is also why hate crimes tend to escalate if they are not stopped. They can lead to retaliation between communities and violence on a broader scale. This is in terms of impact. In terms of technical or legal aspects, what makes hate crimes different is that they are defined by the motives of the offenders. And this is a complication because our law enforcement does not work every day with motives as a legal term. This is what makes it sometimes difficult for the law enforcement to recognize hate crimes when they're reported, to record them. It makes it harder to prosecute them. So all these aspects make dealing with hate crimes both important and complicated. And of course, none of this will ever happen if victims do not come forward to begin with and do not report. So this is just by way of introduction. I would like to focus in my presentation today on what can be done. I agree with a lot of what has been said already, what the previous speakers mentioned. Lots of aspects of reporting or underreporting are the same, and then there are some which are different for victims of hate crime. I will not introduce ODIHR and our work around hate crimes too much. Oops, sorry, I'm rushing forward. Let me just say here that all the EU member states, which also happen to be participating states of OSCE, the organization I represent, have committed themselves to do a number of things to address hate crimes, including a specific commitment to encourage reporting of hate crimes by the victims. Levent already spoke about what we do in ODIHR. Hate crime is a big focus for us. So we work with national authorities, we work with civil society. I will not go into details. Perhaps I should mention a specific project that we have now, which is called eStar, that is developing various tools to address hate crime victim support and the needs of hate crime victims. And we are also leading the European Commission's high-level group on hate crime and hate speech, as it is called now, one of its working groups that deals with hate crime victim support. Few pictures. A picture is worth, I don't know how many, 1,000 words, I think. I will not describe stories behind these pictures, but this is just a reminder of what hate crimes actually look like. This is not a theory. These are real people that suffer real harm. Hate crimes produce real victims which are really seriously hurt. The document that I referenced earlier, the Ministerial Council, OSCE Ministerial Council decision from 2009, that all your countries signed up to, also provides a definition of a hate crime. So hate crime is a criminal offense committed with a biased motive. I think what's important about that is that there are always these two elements. So first of all, there needs to be some conduct that's criminal under the national criminal law. And then the motives that can be homophobic, that can be racist, that can be anti-religious, and is the motive of the offender. So hate crimes are not defined by the identity of the victim. Perpetrators can also make mistakes as to the identity of the victim. We have victims by association, but it's their motivation that defines what a hate crime is. Again, making it harder to record hate crimes as hate crimes, because it's the recording of this potential motive by the police and gathering relevant evidence that then enables prosecution of the incident or the crime as a hate crime. So a few words about what we know about underreporting of hate crimes. Maybe I will start from the end. The first question perhaps should be, what do we know about reporting of hate crimes? And we know about hate crimes and how many and which hate crimes are being reported. We know about that when the country in question has put in place a bespoke system for recording and data collection. And as I said already twice, it's not always easy. And the data that many of European countries actually are able to produce are extremely poor. So my starting point is we actually don't know how many hate crimes are being reported. And of those, how many are being recorded. That's the starting point. Most academic literature, FRA research and other international organizations research, as well as national surveys, often tell us that about 70 to 90% of hate crimes go unreported. Now, this is, of course, an extreme number. This is a very high number. And I think this is unfortunately often the reality. The levels of unreporting or non-reporting differ based on which group hate crime targets. So there will be groups which suffer long-term marginalization, which are even less likely to report when it happens. There are groups which do not enjoy, do not benefit from robust civil society, which works with them, supports them, which are even less likely to report. Looking at some of these numbers, it's also important to, I think, be a little bit more granular, not jump to quick conclusions. It is important to ask follow-up questions. So when we speak about underreporting or non-reporting, what do we actually mean? Unreported crime to whom? Do these research papers speak about not reporting to the authorities only, but they would include as reported crime which is reported to NGOs, for example. We also need to look at, specifically when it comes to hate crimes, we need to look at reporting of what. As I showed, hate crime consists of two elements. So there's a base offense, let's say physical assault, and then there's bias motivation. So what do these studies actually look at? Is it about the reporting of bias motivation only? I think research shows that the more severe the crime, the more severe the base offense, the more likely it is that the incident will be reported to police. And the question whether police, whether the victim reports the bias motives and whether the police record the bias motives is yet another, a separate question. So in terms of reasons for not reporting, I don't have much to add to what previous speakers mentioned. Clearly, the word trust in the authorities is very important. Victims are often skeptical about the action, the response. They're worried about being re-victimized at the hands of criminal justice system bodies. Many of the victims have normalized a certain level of discrimination because they come from communities that deal with this on a daily basis. Often we hear or read that victims also lack information and they don't know how to get any support. Before going to what can be done, I wanted to say that there is obviously one way to find out how much and what hate crime is not reported to the authorities, and that way is to go to the victims or to the communities which are victimized and ask. Now, one of the approaches is a general crime victimization survey, where questions about hate crime victimization, experiences with support, with response by the authorities, so such questions can be included there. Now, you either have it in your country or you don't have it. And if you don't have it, you probably won't be able to organize single-handedly a comprehensive household crime victimization survey. Perhaps a more feasible option is to take a more detailed, more granular, more focused look at some aspects of hate crime victimization, perhaps at some communities only. I listed here some of the examples of work that ODIHR has been involved in. There are obviously lots of different methodologies and approaches. If you are thinking about conducting something like this, please get in touch. And then, of course, there's the international research, which also gives us a lot of important information. As I mentioned before, one has to be careful when interpreting it, make sure to understand really well the methodology behind that research before drawing conclusions. Now, on to what I think are the priorities? First, for the law enforcement and authorities generally, I will also then speak about what I think activists and civil society organizations can do. This is very much focused on increasing and improving reporting of hate crimes by the victims. So when I start with a very general sort of notion, collaborate with civil society organizations and conduct community outreach, I'm thinking about that in terms of increasing of the reporting, although it has many more aspects, obviously. What I'm talking about, or what we are talking about here, is a very basic principle that the closer the authorities are to the communities that are targeted, the more likely it is that the communities will know them, the communities will trust them, and the victims from those communities will report. So concepts such as proximity policing or community policing, setting up liaison officers in precincts and similar, these are all practices that have been shown to have impact on the reporting rates. When it comes to collaboration with CSOs generally, and civil society organizations generally, any collaboration is better than no collaboration. NGOs often have better access to the victims. Victims have access to the NGOs. NGOs, some of which may be community-based organizations, also have information about what's going on in their community. So any collaboration will help. They can be also instrumentalized or used as a channel for disseminating organization. And there are lots of good examples how this collaboration can be actually formalized and turned into very, very practical and very beneficial scenarios. Second point, enable alternative reporting channels. I call them alternative. They are very popular, and there's a lot of chatter about these in different international fora about scenarios such as enable anonymous reporting, enable third-party reporting. It's not always enable reporting online. It's not always so easy when one dives into details of how these things work. I will talk a little later about third-party reporting, but let me just say that these reporting alternatives should not create false expectations in the victim. For example, online forms can create the impression that the victim will actually get emergency support if they go through that channel. It can create impression in the victim that their identity will be protected throughout the whole process, which might not even be possible eventually when police start investigating, etc. So, but it is a good practice. It just needs to be really well thought through and operationalized.
Alesh, I'm sorry, you have 5 minutes left for your presentation.
Thank you.
Thank you.
Third point, recording an individual needs assessment. And I think we all know what the needs assessment is about. I'll focus on the recording. Recording of hate crimes as hate crimes. This is what I mean here. And why is it important? It's important because if hate crimes are not recorded as hate crimes by the police, so recognized and recorded, they will probably, one, not be prosecuted as hate crimes, and perpetrators will probably not be punished. Two, the police and criminal justice system will not have data that can then inform policy making and prevention. And three, and perhaps that's the most important point here, if there are no hate crimes, there are also no hate crime victims. And so from the perspective of the state bodies, it's this moment of recording hate crimes that actually creates hate crime victims. And if that doesn't happen, we have a victim that understands why they've been targeted. It's on the grounds of for some identity traits that they have. And we have a state that doesn't agree that this was a hate crime. And that really can produce a lot of problems. Very quickly through the three remaining points, I included understand hate crime victimization, and I think a previous speaker also made a similar point, trauma-informed response or something similar. Sorry for paraphrasing. I think when states are designing victim policies, they need to make sure that they actually understand what hate crime victimization means and what hate crime victims go through. If that doesn't happen, lots of follow-up action and policies and forms and steps will be off target, and they can actually be counterproductive. When we speak about safe reporting and safe reporting for victims of hate crime, obviously, and this is a requirement of the Victim Directive, as you all know, training for sensitive and respectful treatment is a must, is necessary. Again, it's no coincidence that it follows after understanding of hate crime victimization, because it needs to be informed and needs to convey the main differences as well as similarities to other victims. And the last point here, communication. I started by saying that hate crimes are message crimes, and they affect wider community, not just the one victim. For that reason, also the response needs to be heard and seen more broadly. And I think police and criminal justice system agencies do not do enough in speaking and communicating about positive aspects of responding to this problem. So a lot should be improved here. I will wrap up quickly. Sorry if I'm being too long. Maybe these are my priorities for civil society organizations. So first of all, monitoring and exchanging data. Many NGOs do monitor hate incidents, do monitor hate crimes. I would encourage everyone to get in touch with the law enforcement and explore the possibility to sit together, to exchange these data. There are ways to do it. We have countries in the EU that have formalized agreements between police and civil society about this. It can happen. The same is true for third-party reporting. Third-party reporting mechanisms are effective if they are based on an agreement with the law enforcement. If the victim does not have excessive expectations, in that case, this is a very effective way of supporting the victim and actually supporting the criminal justice process. And two last points, and perhaps this one is a bit provocative. Based on our experience, we often see that NGOs and activists, which do a lot of very good work with victims in monitoring of hate crimes, in advocacy, do not really have full appreciation and full understanding of methods of work of the law enforcement, which really complicates communication. So I would encourage for you to really map how police actually work with incidents in your country context. And then the last point, based on that, again, to ease the communication, is coalitions, get together with others to be a more legible partner for the authorities. This is something that we keep hearing from police, which very often are actually very well intentioned and would like to speak with civil society, just don't quite know with whom they should be speaking. I will not go over these. These are some of the ODIHR tools specifically dealing with victims of hate crime. There's also a training and guidance on sensitive and respectful treatment of hate crime victims and others. You see the link, and I will share the presentation. So hopefully you will be able to check for yourselves. I thought I would also address a little bit the online hate crime versus offline hate crime, hate speech, cyber hate. There's an argument here behind this slide. Maybe just to jump to my conclusion very quickly. Legal qualification, when we're talking about crimes committed online, should always take into account the experience of the victims. There's some recent judgments from different European constitutional courts about this. And why it's so important is also that European law does not dictate what is actually a hate crime. It only affords enhanced protection to hate crime victims, not hate speech victims or online speech victims. So the definition of what is a hate crime is left to national bodies, national authorities, national consensus to define. And for that reason, again, these national definitions and conceptualizations should probably include the experience of some of the victims of crime online, which can very often be very similar to those of victims of offline hate crime. And I'll stop here. Sorry for being a bit too long.
Thank you so much, Ash. I think that was extremely interesting, and I think we see lots of crossover, not only between certain and specific groups of victims, but we can see that there are actions which can benefit all kinds of victims. Some of those solutions for the way that reporting should be achieved, I think we see a lot with respect to training. I think we'll have to look, and it'll be interesting to hear from Sepol about how you incorporate all of this training into a busy agenda of the police and justice practitioners. So thank you so much for that. I'll quickly move on to our next speaker. So we're now going to hear from Alexandra Anakina, who's going to talk to us about how research can be used as a tool to overcome the challenges of underreporting. And Alexandra is a communications officer at the European Institute for Crime Prevention and Control, affiliated with the United Nations. It's a lot of people will know it as HERNI, which is based in Helsinki. And their objective is to promote the international exchange of information on crime prevention and control among European countries. So, Alexandra, the floor is yours. Thank you.
Thank you very much, dear colleagues. It's a great honor for me to join you today, and I'm looking forward for even more presentations, even though I think already discussion this morning was a very refreshing perspective. And I would also like to extend my gratitude to the conference organizing team. Your effort to make this event happen is just tremendous. And as previously mentioned, I do represent HERNI, which is an independent research and policymaking institute in Finland. We work together with the Finnish Ministry of Justice as well as the UN Crime Program. And we have been researching gender-based violence in particular since the end of the 90s. And as a part of the European consortium, we have received EU funding in 2017 for a very interesting project called Co-Creating a Counseling Method for Refugee Women GBV Victims. Now on this slide, you can see some data gathered from that project. And the methodology that we have chosen was quite innovative at the time. We were working together with the NGOs all across Europe. You can see their names on the slide as well. And in these 6 countries, we have gathered data from 30 counselors working together with the victims and refugee women. And it actually showed us like what are the real problems of doing the counseling and the victim support. And that was also very interesting to analyze why, as you can see, out of like quite a huge number of counseling sessions and a huge number of suspected victims, only rare cases were taken and reported to the police. And based on this data and the report called Unseen Victims, you can see that we have a continuum of violence, and that's actually one of the main points and reasons for underreporting, because refugee women's experiences of violence form a continuum over time and geography. And there is a great risk of re-victimization for refugee women who arrive to the EU already with certain history of abuse, and just changing the forms of violence really makes this continuum a big pressure for the women. And reporting gender-based violence incidents to the police is not a primary concern of these women, because they try first to seek an asylum and to get some peace of mind. And in order to recover and gather this courage to report, these women would need asylum. But in order to receive asylum, they need to tell their story of the abuse. So this dilemma creates sort of, vicious circle for many of the refugee women. And continuing this idea of the victim's dilemma, we know that there are two systems aimed at protecting and upholding the human rights for asylum-seeking victims of violence. The first one is the asylum system, which is aimed at protecting those in danger of persecution of serious harm. And there is also the victims' rights regime, which seeks to ensure protection for victims of crime. But the expectations of these two different systems, the asylum system and the criminal justice system, do not correspond to the realities of the refugee women. And this is what we gathered from the data, and it has been like very repetitive in all the journals, that in order to build a future and to recover from violence, the women would need asylum. But in order to receive it, they need to concentrate on and emphasize the most intimate and shameful incidents of their life. To try to reassess that and find out how to move forward, we have picked like two very important parts in the counseling. That first, informing women on their rights is one of the bases and the keys to go forward with challenging underreporting, and of course mentally supporting women to tell their story of violence. Also, we have noticed that in order to proceed with the asylum system, women need the information how to tell a story, how to tell their experiences in a manner that corresponds to the system. And that adds yet another layer of these challenges of why women do not report crime. But in order to provide some concrete examples of how we can move forward, we've made some policy recommendations that are available in the last chapter of the Unseen Victims report. After the end of my presentation, I would like to share some links in the chat, so you would be able also to go through the materials. There's quite a lot. So coming to the policy recommendations developed, we tried to put them in different groups. So the first category emphasizes the steps that should be taken to improve the gender sensitiveness of the asylum system in order to tackle this disadvantaged position of women in the process. And the first point is, of course, to identify victims of gender-based violence. And it's really a time-sensitive issue. It needs to be done as soon as possible upon arrival in order to prevent further victimization and making the trauma even deeper. And thus, we need to be able to refer identified victims to relevant services. Next point is providing more information on gender-based violence and the rights related to the asylum process. And that's a bit of a challenging point because we need to do that in a very understandable format and understand that there are many languages and that it's already a huge stress for a person to come to a new country. And we would like also to also remember that there is a very specific legal language and there is certain limit of what people can understand before they can actually understand what are their rights. Of course, we need legal representation for all the victims, and it should be free of charge from the very beginning of the process. So a legal aid provider should explain the asylum process and its requirements. And it's also a bit of a tricky situation so that the person in question would actually be able to grasp what the system wants from them and what they can get from the system. In this particular project, we also noticed that there is a huge gender-sensitive need to also being able to have a female interpreter in many cases of gender-based violence, because a qualified interpreter can also help to reduce some of the stress and the trauma of the process. And sharing certain details, as we have heard also today, is very challenging for the victims. So in order to make it at least a little bit easier, we would also recommend to have this opportunity to choose a female interpreter who would also be supporting the person throughout the whole process, so there wouldn't be the need to retell your story way too many times. The next point is having an individual asylum decision. That's also very important for people who are in a situation of codependency, and often in the gender-based violence cases, it's a huge problem as well when the traumatized victim cannot actually get out of this vicious circle also because she is codependent. And of course, we need more and more training and guidance on the gender-based violence. It was really hurting today to hear the experiences with the system where professionals unfortunately didn't have proper access to training or didn't really understand how does a traumatized person live like. So I think that's a huge challenge in our system as well. From that, we can move to the victim-centered criminal justice process. And I think this is something that we keep talking about like every year at all the events, but we need to move on to the victim-centered criminal justice process. And it includes reducing the length of the process, easing the procedural demands on the victim, and finally reducing the risk of the re-victimization. One of the key rights here is a right to understand and to be understood. And that should be also be during the whole criminal process. That should be taken into consideration the personal characteristics of the victim, such as gender, disability, age, maturity, and relationship or codependence on the offender. And once again, we are coming back to the question of the interpreter and the support person. And again, the systematic training, and it should really be systematic and not like one time in a year thing for all the professionals in the field on all forms of gender-based violence. And in that context, it's also important to have training models on dynamics of power and control and how to encounter traumatized victims. And of course, it should be important that we have proactive referral by criminal justice authorities to specialist victim support services to just build a bridge between this gap of the two systems. And the third group of the recommendations aims to improve access to services for refugee women victims of gender-based violence. And we believe that it should be irrespective of their resident status, because again, otherwise they are falling in the cracks of the system and do not get the services and support that they deserve. So one of the first options we would like to highlight is to provide multidisciplinary services. And that's very important because women in this situation usually have suffered from multiple forms of violence, and they need different support services simultaneously. And that includes both legal help, social support, housing, proper medicine. And that's really tricky when you cannot get all the services working together. And that also includes long-term psychosocial counseling to all the women which were victims of gender-based violence. And of course, there should be the access to shelters. But it all sounds really good, and it would make our world better. But the key point is also that there should be funding for these services. And it's very challenging to hear all the stories with the NGOs that sometimes they also struggle with the funding, or it's also like project-based, and it's a bit hard for them also to manage the process as a whole. And that's also something that should be ensured both on the national and the EU levels, that there should be funding, that it should be stable, so the NGO workers would also know that they would be able to provide help today, tomorrow, next month, and next year. So that's a very crucial part. And as a communications officer, of course, one of my favorite topics to talk is the means of dissemination and how to make this communication efficient. I think we have already discussed today that it's one of the key points in this process of tackling underreporting. And in our work at HEONI, we have seen that we try to separate 3 target groups, because they really need different tools and different languages used. When we worked with women in migration, we really noticed that we cannot use the same jargon as we talk with our colleagues or assistant providers, and that in our materials we tried to move to more graphic material so that it would be also easier for different NGOs to use it across Europe, no matter which language or language skills are needed to disseminate this information. We also noticed that sometimes you have to make it as simple as possible, and it doesn't matter if it doesn't look, perfect from the graphic point of view or from design. It should be understandable. So that's one of the keys. Then we also were experimenting with the formats, and the recent success, at least we hope so, we had some nice feedback on using podcasts. And the idea of this particular podcast was to encourage and empower women who have already moved on from their story of being a victim, and that they tell their story, share it, and also use it as a conversation opener during the counseling sessions. So we have recorded in 4 languages survivors of violence, and it was also an interesting experience from their side, because they're not professional speakers, they're just women who had this terrible experience, but they have replied to us after recording sessions that it was a very refreshing experience for them as well, that now they feel that they can share their story and help other women to come forward. And,
Alexandra, I'm sorry, you have 5 minutes left for your presentation.
Perfect. I'm trying to wrap up a little bit, so bear with me. Thank you. And of course, as a part of the Finnish government, we try to work with the policymakers, and in that case, for us, it's more or less, classic that you do policy briefs, you do expert meetings, and try to find actors who really are able to see the big picture and make the change. And of course, we try to help our fellow NGOs and assistant providers. And in that case, we try to make products a bit practice-oriented, such as handbooks, diaries. So it would be also interesting to discuss in future with some other providers, like what would you need in your work, in your daily work, and what kind of help you would like to get from the researchers, like how we can help each other. And here are some examples of the formats that we have used. I will post all the links to the chat as well. As you can see, we have just recently published a toolkit for enhancing counseling sessions, and it's targeted not even for the victims, but actually for the counselors. So the counselors who meet the victims can use some reflection both on the process and their own feelings, because it's also a very hard work and a very huge burden. So we would like to lessen this burden, and together with practitioners and victims tackle the underreporting. I thank you for your time. That's my last slide. We are celebrating 40 years this year at HEONI, so I hope we will stay in touch with you, and please put your questions to the chat room as well. Thank you.
Thank you so much for that presentation. I think there are so many crossovers between what you said, obviously between what Nicolette spoke about earlier, and also what Alex talked about. And I think when we see some of these issues, if we take something like communication and awareness raising, we heard both the Commissioner and the Assistant Director talking about the aims next year for the European Commission to do awareness raising. What's critical is understanding your target audience and understanding your objectives, but also working together. I think we see how important awareness raising is. I think it's often not as impactful as we'd like, but the more we work together to do that, the more we work in the communities. You've produced all these amazing documents and different kinds of products to communicate. The more we work together to disseminate that information, I think the better. And some of your points, I think, are extremely important for the coming year. We have a new gender-based violence directive that will be proposed, the issues around how you ensure a gendered approach in support, in justice, even thinking about some of the points that you made about the interpreters in the EU Victims Directive. There is a right to be interviewed by a same-sex police officer in certain kinds of cases, but there's no mention of the interpreters. And as you recognize there, it's not enough for it to be just the one. You need the system to be gendered and not just one part of it. So I think these are really important points that we can recognize, not just for asylum seekers, migrants, but for others as well. So thank you very much for that. And we will now move on. Let me just quickly go back to my script. So we're just coming up to the to a coffee break. We had, of course, we were planning on doing this live. We planned quite a long coffee break for everyone so that we could all talk together, meet together. But in any case, we will keep the coffee break to the set time, which is coming back at 12:30. Before you all disappear, I just wanted to let you know that that we are running an evaluation. We normally do this. It's really helpful to hear back from all of you about how you found the conference. There is actually a QR code that you'll be able to scan so that you can go and fill in the QR code. And we know that there are participants watching us on Vimeo. So the video live stream will be paused during the break. And then we'll restart. We return at 12:30, that's Central European time. That's in 28 minutes time. So thank you very much to all of the speakers. It's been absolutely fascinating. I think there's a lot to think about, a lot of actions for next year, and we hope that at all levels we'll be able to take something forward. So we'll see you in 12:30. Thank you. So welcome back, everyone. I hope you enjoyed that very nice, relaxing music. I hope you're not too relaxed, because I feel like I could just chill out now. We have some fantastic speakers for our next session, which is focused on modern solutions to effectively support victims in criminal proceedings. So we're in the pre-proceeding phase, talking about safe reporting. We're now moving into the point where victims have actually come forward. They've reported the crime. The question is, how do we make those criminal proceedings safe, effective for victims? How do we meet their needs? How do we ensure that it's adapted according to what each victim needs? So this is really where we are now. Before we go into this critical reflection on the criminal justice system, we're going to have another quick poll. So can I just invite all of our participants to have a look at this question now? It's poll number 2. It's asking you, which of the following areas related to criminal proceedings should be a priority for improvement in the coming years? And we thought this was particularly relevant given the activities of the European Commission next year, but it's also important because there's lots of practical action that's needed. We still have legislation at the national level, rights at the national level. And the question is, how do we need to improve those? But what areas do you think should we focus on? Should you focus on? Should institutions focus on? So I think we're getting near to, we've got 100% answered there, is that right? We'll give it a few more seconds. I see we're still going up, 36 of 70. I know this is a difficult decision. We only gave you one choice to make your lives more difficult. Okay, we've got up to 40 of 70. I don't know if others are going to be replying. It seems to have stabilized around there. So we'll close the poll in 5 seconds. Get in your last votes. Oh, it's gone. Too late. So we have there, I think that's closed now, isn't it? So we have now 15% really think that we have to focus on reporting of crime. We've got 5% physical protection in proceedings, the protection orders, protection measures, 10% accompaniment during proceedings, 12% on effective communication with victims during proceedings, and look at this, 41% of training of law enforcement and justice practitioners. This is, to some extent, an obligation under European law. It's a full obligation for law enforcement, but under EU law, considerations of independence of prosecutors and the judiciary have not meant it's an absolute obligation for those groups, at least not at EU level. So it will be interesting to hear how we can take that forward, how we can get training embedded more. And there we see emotional support in proceedings is at 10%. So that's a real interesting variance with one very strong focus on training. That's really helpful. It'll be interesting to see with the next panelists if you change your opinions over time, if you see that there's other areas which have more importance. So if we just close the poll, I will now move on to our first speaker of this session. We have an hour before we go into lunch, and I have the absolute pleasure to welcome Suzanne van der Aar to speak, and she's going to actually provide us with something of a critical analysis of criminal justice systems. I've had the real honor and pleasure to be able to work with Suzanne for some years now. She's a full professor of criminal law and criminal procedure within the Department of Criminal Law and Criminology in Maastricht University. And she carries out a whole range of research on victims of crime, victims' rights within the context of criminal proceedings. And she's also led numerous national and international research projects involving victims of road traffic offences, intimate partner violence, protection orders, qualified victims, property crimes, and much more, I know. She's also been responsible for taking forward research and assessment of what the Council of Europe should do next for its provisions on victim assistance as well. So I would say, in my humble opinion, she's one of the preeminent victimologists, at least in Europe. And it's my great pleasure to welcome Suzanne. The floor is yours.
Thank you, Lev, and also thank you for raising expectations. I hope I can live up to those. I'm going to share my screen with you. Can you see that? Yes. Let's see. Yeah, the title of my presentation is Victims' Rights, a Critical Breakdown of EU Justice Systems. Now, please do not be worried. I will not name and shame any individual EU member state, but I would like to talk in more generic terms about the problems I think all EU member states face when it comes to these victims' rights within the criminal justice system. But if the shoe fits, please be welcome to try it on. What I'll be doing for the next 20 minutes or so is, first of all, sketching the problem of unsafe justice. I will not elaborate too long on that topic because you've heard a lot about unsafe justice this morning. But I think it's clear that we have a problem. And in my opinion, there are, well, you can distinguish 4 important causes. Possibly there are more, but I think these apply across the board. So they are victims' rights versus defense rights, and how can we balance those legislative and practical blind spots, victim hierarchy, and practical impediments to implementation. But first, unsafe justice. I think it is important to highlight that much progress has been made. So I would like to start on a positive note. I think that the situation for many victims now has much improved in comparison to the situation in the 1980s or earlier. So Hooray for that. But the fact remains that we do have a problem still. And you can see this in various studies, in victim studies, victim surveys, but it is also reported by the European Commission in last year's report on the implementation of the Victim Directive. If you read through that report, it's not too long, I would highly recommend it, but it is concerning. Basically, the European Commission says that many member states have not or incorrectly transposed the EU Victim Directive. And mind you, we're talking about minimum standards here. So we haven't done it, or we've done it incorrectly. The report also raises concerns regarding practical implementation. So if the rules are transposed into law, it's not always implemented in practice. And shortcomings are seen when it comes to the right to information, protection services, victim services, and protection in most member states. So there's still much to be gained. Well, what could be lying at the root of these problems? Why do we still have unsafe justice for so many victims? I think one of the main problems is that we're still looking for a balance between victim rights and defense rights. We still haven't struck the right balance yet. We're struggling with that. And I noticed that whenever new victim rights or measures are introduced or are proposed, these proposals meet with almost automatic opposition, or they are limited only to a subset of victims and not to victims across the board. And this opposition comes from various angles. Think of defense lawyers, but also organizations representing the judiciary, legal scholars, practitioners. And sometimes they're opposed to victims' rights that do not even affect any rights of the defendant, or sometimes you see limitations there. Think, for instance, of the limitation of certain victim support services to victims who have filed for a complaint and not others, or to providing victims with certain types of information depending on their role in the criminal proceedings. Whereas this limitation, if you look at it strictly, is not really necessary. It does not impact the defendant. So there's no need to not elaborate or to not extend those rights to other victims as well. There's also opposition or limitation to those measures that do not affect fair trial rights. So yes, the defendant is affected, but not to the extent that the fair trial is impeded. In the Netherlands, there was now a debate on the compulsory attendance of the defendant during the trial. So this might sound strange to people from other countries, but in the Netherlands, you are free not to attend your own trial. That is your liberty. But that has changed now. So for certain suspects, there is compulsory attendance, also with an eye on the needs of victims. Certain victims really appreciate it to have the defendant there. For instance, if they want to make a victim impact statement. Now, the European Court of Human Rights has specifically indicated that compulsory attendance does not form a violation of a fair trial. But still a lot of opposition because, of course, you know, the liberties that defendants used to have are now limited. Then, of course, there is the situation when new victims' rights do affect those rights of the suspect. And if that is the case, you often see that the latter rights prevail, so that the rights of the suspect trump those of the victims. That is true when unequal interests are at stake. Think, for instance, of the situation when you have a prohibition order, so a no contact order, or you're not allowed to go to that area. Typically, it's rather difficult to obtain such an order as a victim, but once it's in place and it's violated by your assailant, by your ex-partner who is violent, it can be even harder to have these protection orders enforced. And in many cases, we're talking about unequal interests. So on the one hand, we have, the safety, the life and limbs of the victim that can be at stake. And on the other hand, it's the freedom and the liberty of movement of the defendant. But apparently, it's even difficult in those situations to enforce the rights of the victim. And finally, there's a situation where there are more or less similar interests at stake. And even then, that situation, it's the defendant's interests who prevail. An example can be found in Article 6 of the EU Victim Directive. In that article, it says that victims can be informed on the release or escape of the suspect, at least where there's a danger or identified risk to the victims, unless there is an identified risk of harm to the offender. In that case, the victim can no longer be informed. Now, it's not as black and white as it's, as I wrote it down right there. There's again a weighing of rights and interests, but it is typical for me. So, in my opinion, all countries are constantly struggling with the rights of the victim versus those of the defendant. Another problem, I think, is that we still, on a national, EU, but also international level, that there are blind spots, situations that we have not regulated, that we have paid insufficient attention to. Taking again the EU Victim Directive as an example, the EU directive basically begins when a victim files a complaint or when the police start investigating a case ex officio. But what about the stage before the filing of a complaint? Well, you discussed this morning. That is a blind spot. We haven't regulated that. I think it is worthy of more attention because many victims do experience barriers there. How can we help them? How can we help them overcome these reporting barriers? And how can we actively provide them with access to justice? The same is true for post-trial rights. Again, the EU Victim Directive also more or less ends once a final verdict has been cast. But victims also have needs in the post-trial or the release phase. For instance, when it comes to protection measures or protection concerns. The right to remedy is at the moment underserved. So we have all sorts of victims' rights. But if they are neglected or violated, how can we enforce those rights? What can a victim do to make sure that his or her rights are respected? There's not too much on remedy out there. I think we need to tackle that as well. And finally, strictly speaking, not within the ambit of my own presentation, but we have a lopsided attention to the criminal justice system, and rightfully so, because this is important for victims. But they also have needs outside the criminal justice system. Speaking of other legal proceedings, for instance, think about civil proceedings, family courts, administrative, police proceedings. I think we need to take on a more holistic approach in that regard. And of course, there is the difficulty of national differences. So EU countries are, well, not at the same level when it comes to the implementation of victims' rights. Is that necessarily a problem? Perhaps no. Perhaps there is a way to work around these national differences. For instance, with the help of some sort of bandwidth approach, where at the EU level, we establish minimum standards, just like we've done with the EU Victim Directive, but then maybe covering more of these blind spots. And countries that are able and willing to do more, we could also try to find ways to inspire those. A third cause or a third problem that I'm also struggling with, but that I also see countries struggle with, is the vulnerability label and the, well, victim hierarchy that more or less ensues because of this label. What I see happening is that more and more groups, subgroups of victims are labeled vulnerable, and they are provided with extra rights. And the vulnerability label can have very important implications. It can, for instance, determine whether you have access to support services, whether you have access to compensation, to protection, whether you can make a victim impact statement, etc., etc. So we're directly differentiating between victims based on you being vulnerable or not. And what many national criminal justice systems use is a more or less binary system of vulnerability. If you share certain characteristics with a vulnerable group, then you're vulnerable. You're either in or you're out. And the hypothesis is that the majority of the population is not vulnerable, but there are certain minority groups that are vulnerable, and they are more or less automatically provided with additional rights. I see various problems with that mechanism. For instance, sometimes you see that this classification, vulnerable or not, is sometimes incoherent and also intransparent, whereas the consequences can be far-reaching. So it is important to provide at least this distinction with a coherent and a transparent justification. The classification is also sometimes based on assumptions and stereotypes, and this could lead to both under-inclusiveness and over-inclusiveness. I'll give you an example. For instance, the elderly are now upcoming as a new vulnerable group. But sometimes you see that there are stereotypical ideas lying behind this classification. For instance, the elderly are vulnerable because mentally they are vulnerable, or they are not ICT savvy as a group. Now, this may be true for some of the elderly, but not for each and every one of them. So how can we distinguish the truly vulnerable from the, well, not so vulnerable? So there's a problem of over-inclusiveness, but also under-inclusiveness. If you look at Article 83 of the Treaty on the Functioning of the European Union, that is where the Eurocrimes are described. Well, in that article, it only mentions female and minor children, or sorry, children of human trafficking and sexual exploitation as a Eurocrime. There is one important group that is left out of the equation, and that is male victims of human trafficking and sexual exploitation. Is that because there are no male victims of these criminal facts? Well, of course not. They are there and they need to be helped and addressed as well. But I think this has to do with the stereotypical image that we have about male victims and male victimization. They are typically seen as being less vulnerable or invulnerable. So that leads to under-inclusiveness. And finally, there are more problems, but I'll leave it to that. There can be negative side effects that we do not know about. So how do victims themselves perceive this vulnerability adjective? Do they, for instance, appreciate it when judges in court emphasize that the suspect targeted a vulnerable victim? Or do they see this as stigmatizing, perhaps? We've had a similar discussion with the word victim. Some victims prefer the term survivor. Well, how about the vulnerability adjective?
Suzanne, I'm sorry, you have 5 minutes left for your presentation.
I'll speed it up from here, thank you. So there can be various negative side effects, perhaps also self-fulfilling prophecy. Also, I've seen some examples of paternalism. So we need to be careful with this label. And I think we need to work towards a more tailor-made approach. And personally, I'm in favor of the EU Victim Directive in that regard. Because in the individual assessment, certain groups are highlighted as, well, red flags. We need to pay extra attention. You know, we may have to deal with a vulnerable victim here, but then through the individual assessment, we want to see if this person truly is vulnerable or not. The problem is that the individual assessment itself has also met with a lot of opposition and a lot of criticism. People thinking that we're overburdening the police and that, in fact, it is impossible to implement this. Finally, The fourth problem is that there are other impediments to practical implementation. These can have to do with the culture within the criminal justice system itself. You still see a lopsided focus on successful prosecution rather than victim needs. And I think we need a balance between those. That has to do with the way that we train and educate people working within the criminal justice system. Also, victim fatigue, some sort of tiredness might play a role in this regard. Another problem could be problems between, criminal justice actors and their cooperation within the system, but also outside the criminal justice system, with health services, with victim support services. Lack of money and capacity, a very important impediment, in my opinion. And then there are all sorts of other impediments that could lead to problems when it comes to implementation of victims' rights in practice. To wrap it up, yes, there's still a lot of unsafe justice out there. I highlighted 4 what I think are generic problems, and I'm really looking forward to discussing these and other problems with you towards the end of the day. Thank you for having me, and thank you for your attention.
Thank you much. Thank you very much, Suzanne. I think you've posed lots of interesting questions there. Let's see how many of those we can at least address or talk about in the coming afternoon. I think some of those points around the balance between defence and victims' rights are really interesting. Even the differentiation, I think, between defence rights and fair trial rights, which I'd never really thought of in those terms, but the importance of that, understanding the difference between those points as well, and this tailor-made approach and how we can, on the one hand, be flexible, targeted, but also not create hierarchies which are inappropriate. Also not label people who don't want to be labeled. I think that's often, as you pointed out, it can be something which victims themselves really don't want to be labeled as this kind of person or that kind of person. So thank you very much for that. That's a lot to think about, and you're coming back kindly later on this afternoon to run a panel for us as well. So we look forward to that. Thank you, Suzanne. So we move on now to our first panel discussion. Let me just move over to a different screen. This is the joys of electronic screens. I have to go to different screens. So we're moving on to our next panel discussion, which is really focused on how we actually have effective support solutions within the criminal justice system themselves. We have some fantastic speakers who are going to come together. We're going to have a conversation of sorts. Always easier face-to-face, but I'm confident we're going to make this work in any case. And we're going to really be looking at different ways in which within the criminal proceedings we can have a more effective support structure in place for victims. And we have some fantastic speakers who I will introduce now. First of all, we have Peter Crawley, who works at Victim Support Northern Ireland. He's the head of service for the Court Support Programme, working with a team of 15 staff and 60 volunteers. And they provide the service across 17 courts. And next is Peter is also he leads on the Victim Support Northern Ireland Restorative Justice Service and on court support for victims. So that's Peter. We also have Dimpna Kenny. She is the General Manager for Victim Support at Court, which is in the Republic of Ireland, and they provide free and confidential court accompaniment for victims of all types of crime. And Dimpna herself has put a huge amount of emphasis on training and development of volunteers and understanding the sensitive nature of the service. And she's led and motivated and managed multiple teams of different sizes over the last 30 years working in the charity sector. So welcome to you, Dimpna. We also have Frederica Mariano Marquez. And I know every time Frederico says his name, it sounds very different to the way I say it. So apologies, Frederico. He's a lawyer and senior advisor and chief operations officer at the Portuguese Association for Victim Support, which is APAV, one of our founding members. Frederico is the technical manager of European projects in different areas related to rights of victims. He's run, for example, the Info Victims project on the right to information, Project Prostasis on online ID theft, Project Victims and Mediation, which is on restorative justice measures, amongst others. So he's been highly active for a long time in this field. So welcome to you, Frederica. And finally, but not least, we have Robin Frontin. Sorry again if I'm pronouncing it wrong. I still have to learn Dutch, even though I'm in Belgium. Robin is the National Legal Policy Advisor at Victim Support in the Netherlands, and he started working with Victim Support Netherlands as a paralegal to support victims during legal proceedings, supporting them during trials and defending their request for compensation and other victim rights. He also became a trainer at Victim Support Netherlands Academy, where he's trained colleagues and legal professionals about victims' rights. And this November, he started his current position as a National Legal Policy Advisor. So welcome to you, Robin, as well. So thank you very much to all four panelists for being here today. The idea behind what we're speaking about now is really to have a look at the ways in which supports can be better provided within the criminal proceedings. And I just wanted to start off first of all with Peter. First of all, maybe if you can just tell us a little bit about Victim Support Ireland's Northern Ireland's work, and in particular what you've seen in Northern Ireland in terms of the way that needs assessment happens, both in the criminal justice process, needs assessment for protection, for example, but also what Northern Ireland's role is within that, Victim Support Northern Ireland's role is within that. So over to you, Peter. I'd like to hear a few words from you. And you're on mute if you're speaking.
Sorry, folks. You think after 2 years I would know that. Morning, everybody. Victim Support Northern Ireland, works with referrals referred to us by police. We have a range of services, like many of you, including hate crime, compensation, legal support, child victims, restorative justice. But we have two big focuses of our work. One is immediately after the crime happens, and one is when the case comes to court. When the case comes to court, needs assessment is probably the first thing that we think of. Our public prosecution service will also think about needs assessment as they are organising for somebody to come to court, and they will do quite a court-orientated needs assessment. Our assessment is probably very personal and looking at social and emotional needs as well as other needs, but really trying to work out that we are prepared and the support is adjusted to serve the needs of every individual victim of crime. So we'll identify how they can cope with court. We'll explain the support available at court to them and invite them to court for a pre-trial visit. So our preparation for victims is about needs assessment. It's about how we can keep them safe at court, and along with our partners in the public prosecution services, understanding are there special arrangements, like many of you, that we need to make sure that they are safe, but also then providing the information that they need to be able to navigate that court system. So those are probably the three focuses for us. I think one of the things that would just briefly like to share with you is something that has been really, really helpful during COVID in particular. We have a virtual court tour on our website that I'll just really quickly show you now as I share my screen, which allows somebody to sit in their home and to navigate any court in Northern Ireland as they as they're trying to prepare for what's coming ahead. Now, let me just see if I can manage this. Yeah, I'll not be able to do that this morning. So can I just invite you, if you do have a chance to do that, to visit Victim Support NI's website. You can literally see photographs and images of every court in Northern Ireland. What it has done during COVID is it has allowed victims of crime who are particularly anxious, who are maybe disabled or for various reasons can't come to court, to literally choose whatever court they're invited to go online from their armchair at home and to look around that court virtually to understand where I will give evidence, who the judge is, where the defense person will sit, where the defendant will be in that courtroom, so that even before they set foot in the courthouse, they are prepared, a little less anxious, and know something of what's coming when they might enter that courtroom. Thanks, Leila.
Thanks, Peter. I think what we'll do is, in a minute, I just wanted to do a follow-up with Dimpler, but we'll get one of the team to share their screen so everyone can see that, because I think the virtual tour that you've created is really helpful. So we'll come back to that in a second. Dimpler, I just wanted to hear, you're sort of on the other side of that border over in the Republic of Ireland. Do you have a similar experience of carrying out needs assessment? Is that something that you do as a service, or is that something that's limited to the police?
No, we don't do the needs assessment. That's carried out by the police on Garda Síochána. So we would get most of our referrals for victims into our service, which is a court accompaniment service, come from An Garda Síochána. So it's when they are referring into us that we would ask them about the certain needs for the victim. And that could be how they're giving their evidence in court, if it's in video link or if it's actually in court. And that's where we invite them to do a pre-trial visit, similar to what Peter was saying, but not virtually. We don't have that facility yet, but we're looking into that. But when we invite the victim in, our volunteer would meet with the victim or the victim's family and bring them into an empty courtroom and explain who sits where in the courtroom, from the judge to the jury, to the defendant, to the legal teams. And if they have to give evidence, we give them practical advice on how to walk up to the witness stand, that they be sworn in. And when they take that seat, little things like bringing the microphone up to their mouths. So when their first words they utter in court will be heard. So they're not interrupted to say, sorry, we can't hear you. So it's very much practical advice. And it's at that visit as well, we can show them the separate area, the victim support area, which is a private area away from the general public, where they can wait in privacy until they're needed in court. And that's really where our support actually happens. We can have the conversation with them, explain what our role is in supporting them through the court process, and explain then when their trial does begin that they will have somebody sitting with them in court for every day that they have to attend court. And that, we will help them through, we listen to them, we make them tea and coffee in the victim support area and chat to them, and just to try and empower them with the confidence to enter that courtroom every day they have to.
Thank you, Dimpler. And it's interesting that we have these two phases, really, don't we? We have how can we prepare victims before they even get to trial, before they even reach the courtroom, and then you have services like yours who are there based in the court and can also provide those tours as well, and make sure that within the trial itself they're accompanied. Frederica, how does it work in Portugal and with APAB? Maybe let's just quickly go back to the needs assessment. Do you think that this is something that's working well in Portugal? Do you think it's something that there's more progress needed?
Yeah, thanks, Lev, and good morning to you all. Unfortunately, that's really a problem in Portugal, because although the Portuguese law that transposed the directive explicitly mentions the duty of the authorities to perform an individual assessment, 6 years after that law was passed, the true situation is that the authorities are not doing an individual assessment. So they do not have any tools to do that assessment, and so they are granting the statute of especially vulnerable victims to victims of the more serious crimes. Let's say like this. So this is really a problem that we are facing here, and that's also where we come in as a victim support organization who has very close contact with the authorities of the criminal justice system. This is one of the tasks that we try to perform. So we try to identify specific protection needs that victim, on a case-by-case basis, of course, that victims might have, so that we can flag them to the authorities and to suggest the adoption of protective measures. Of course, that then it will depend upon the authority to adopt or not adopt the measure that we suggest. But concerning that, I'd like to say just a couple of things. First of all, we feel that these suggestions that we do in terms of protective measures needed are better accepted when we have our services working in court facilities. So we now have some services in the prosecution services and court services, and as the relationship with the prosecutors and with the judges is closer in those situations, they I think that they trust more in our opinion and in our suggestions. Then we have another problem because not all the protective measures that are mentioned in the directive were transposed into the Portuguese law. One of the examples is the right to accompaniment, which was not fully transposed into the Portuguese law. Another example is that victims with specific protections need shall be interviewed by professionals with a specific training to do that. And that was not transposed. And this is causing a real practical problem of bad interviews to victims, bad in terms not only of causing secondary victimization to victims, but also in terms of damaging the evidence, the collection of evidence. And just to conclude, another problem is that these measures are not always enacted in what we can call the time of the victims. For example, when we suggest that the trial takes place without the presence of public, we do so because it seems to us that it will be a fundamental factor in ensuring that the victim will appear in court less anxious, less nervous. The problem is that in many cases, the judge replies saying that that decision will only be taken in the day of the trial. And this does not allow us to prepare the victim in a way that he or she is already freed from that concern of having to meet the offender in the day of the trial. So it's also a problem not only of the measures that are there, that are available, but also when they are applied. Thanks, Lev.
Thanks, Frederica. So what we're talking about really is who carries out these needs assessments and how well qualified and positioned are they to do that? And I suppose the question also is, can this system really work without victim support being involved? And it seems like when you are part of the process of making suggestions and where actually you're in a situation where you're trusted, that works better. Robin, is that a similar experience in the Netherlands? Is Victim Support Netherlands part of that process of either carrying out needs assessment or making recommendations on protection measures, or how does it work maybe in the Netherlands?
Yeah, thanks, Lev. In the Netherlands, the situation is a little bit different. Of course, it's only the police who carry out the needs assessment, but members of Victim Support Netherlands, either the legal representation side of Victim Support Netherlands or the emotional support side, are also in contact with the police and the public prosecutor's office to create some sort of checks and balances system with the individual needs assessment. I think that's highly needed because we just had national research on individual needs assessment, and the title of that research was Individual Need Assessment, a Vulnerable Right. And I think that says a lot about the conclusions of the practices of individual needs assessment in the Netherlands.
Maybe you can tell us a little bit more about what were some of the conclusions or findings from that report.
One of the main findings is that it's very dependent on the time the police officer who takes the charges has to fill in properly the needs assessment. Then, of course, it's sent through to the public prosecutor's office and Victim Support Netherlands. Not all victims we know want the support of Victim Support Netherlands, especially in those cases. The individual needs assessment is based on either wrong material or less material than there should be out there.
Thank you for that, Robin. And I think that timeliness, Frederica, you were talking about, it's the timeliness of the assessment but also the timeliness of when the measures are brought in. Peter, did you, we were talking about this before, did you mention that in Northern Ireland there's been some research or findings around this?
There's certainly a change coming, Lev, in Northern Ireland. As I say, the Public Prosecution Service have been doing needs assessment for a long time. That seems to focus on your physical needs coming to court, anything else you might need in terms of communication or disability, things like that. Next year, there's a plan in Northern Ireland for victim support to come together with the Public Prosecution Service to merge, to do a much improved needs assessment, which will combine what they currently do with our work on the personal and emotional, the story behind the crime, and just what that individual victim one by one is bringing to court, and what different needs that. So that would be a big change to that. So it'd be quite a big piece of work for us next year to work with our partners in the Public Prosecution Service to provide one needs assessment process, which we hope will be more holistic and certainly much more victim-centered.
That's really interesting. So what you're saying is that the needs assessment, I'm just taking what the European legislation says, the current needs assessment under European law is focused on protection measures within criminal proceedings. It's not really focused on support measures. And we understand that was established because of the limitations of European law, but also I suppose the limitations on what police can really assess and if they're the right people to assess support needs. You're saying now that in Northern Ireland, the recognition is that you need to combine both, but to do that well, you need to have victim support and the prosecution working together. That's really what you're trying to achieve next year?
It is, and I think a special measure that the prosecution service, police, courts might decide is relevant for a victim of crime, I think will be better informed if the needs assessment process is more victim-centered, as we hope to improve it. It also is going to mean next year that we might have to co-house, so we'll be working much more closely in a new way with partners in the Public Prosecution Service, and that's going to be a challenge for us next year.
Yeah, no, we heard the European Commission mention the importance of multi-agency cooperation, multi-agency centres. I think, just coming back to you on this, and I think again about Frederica's point about trust. How did you get to the point in Ireland where you have this service established in the court where you're working closely together? I'm thinking like the same for in Northern Ireland where NGOs, charities are working with the state to deliver services. How did that develop in Ireland?
Just from our own perspective, we have a permanent presence in the Criminal Courts of Justice in Dublin, which is a building that houses 22 courts, from district, circuit, central criminal court up to special criminal court. So having somebody on site and working, we work with other support agencies. So while we're the only ones that provide support at court, you might have other agencies, say, that would support victims of a certain type of crime or a certain gender. So we will work together, and particularly in the victim support area, to make sure the victim's needs are met. So having that presence in the building is essential, and particularly, say, for domestic violence victims, where the incident may have happened the night before and they haven't had time to link in with the service, so that they can literally get in touch with us on the morning they're coming to court, and we will be there to bring them up to the victim support area. But working together with the other organizations, some organizations we provide training to, and we explain our service, so they concentrate, say, on the supporting the victim from the time the crime happens up to whether it gets to court, and then they'll refer it into us for the court accompaniment side of things. So they may come in the first day the victim is due, their trial is due to start, introduce the victim or the victim's family to our service, and then sort of hand over the case, so they know that the victim is going to be supported every day that they come to court. And that's really working well, and we do that with a few organizations.
And I suppose you can see the importance of the coordination mechanisms there. And I think if I hear rightly, in Northern Ireland and in the Netherlands, it's one organization that runs both the support before going to courts, but you also, are you operating in the courtrooms as well, Robin? Is that the case for slachtofferhulp?
Yeah, Victim Support Netherlands often, especially our paralegals, work as the legal representation of a victim and support, for example, their claim for compensation. We defend that in court. So we have, during the entire process, a more legal representation supporting a view of the victim as well.
Let me just go back maybe to what Peter said earlier. I'm just keeping an eye on time because I could end up focused on this all the time. I still want to come back to the trust issue as well in Portugal. Peter, you were talking about accompaniment. Maybe before we actually go into that in more detail, could someone from the team maybe share their screen and just show the Northern Ireland virtual tour? So here we go. Peter, do you want to just maybe explain how this virtual courtroom works?
Yes, thank you for your technology. So literally on the website, you'll pull up this screen, and on the left-hand side menu, you will have every court in Northern Ireland. So we can select any. If we select Derry, Londonderry, and you'll see there's 4 courts there. Let's select Magistrates Court at the bottom, and that will produce the image of the actual court. You can then click on the white arrows and walk around the courts. If we go up again and move forward, you will see info points. The little blue circles will arise. Any one of those will explain this is maybe where the defense sits and what happens there. One of them will explain where the witness box is, where I give evidence. And if you hold your mouse down and move around, you can look around the court, which helps you just to see, okay, I might be in the witness box there. I also know where the defendant will be. So it's a really good way, without having to come physically to the courtroom, to see any court in the land and really put a few of your questions and your anxieties at rest.
Thank you for that explanation, Peter. And very good modeling by whoever's doing that. I think it's Lee's a lot. So that was very fluent and fluid in the way it's done. Frederica, how do you do that in APAV? I'm thinking now we've got this point where you're working with some victims and it's really important to help them prepare. How do you do that in APAV? Do you have similar virtual courtrooms? How do you explain to them what's going to happen to them? How do you reassure them? And also, how do you find that balance between preparing and helping them, but not going to the point where you could in some way influence their testimony?
Yeah, let me say that this task of accompanying victims and witnesses both at the police and at court as well is a task to which we at APAV are giving these days particular attention because of our growing experience. And this experience is showing us that the accompaniment of victims is one of the aspects of our intervention that has a more immediate, a more practical, and more even visible impact, which I would say it has an almost instantaneous power of change for victims. It's a right that has been gradually introduced in the Portuguese law, although not fully, as I said. Also is entering now slowly in the routines of the judicial and the police authorities. And I would say that, for example, at the end of this year, we'll probably have carried out around 1,000 accompaniments of victims in courts. Most of the cases in pre-recorded evidence sessions, but also in trials and in police hearings. But our perspective is that accompaniment shall take place also in other judicial acts, like, for example, forensic exams, or, for example, the crime scene reconstruction. And we also had that experience, although in very few cases. And we are accompanying, in most of the cases, victims of domestic violence, but also victims of child victims of sexual crimes, and some cases of attempted murder or relatives of murder victims. But again, we think this is a right that shall be there for all victims of crime, and not only for some groups or for vulnerable victims. And our experience so far is very good. We don't see accompaniment as the mere act of being there in the day of the hearing and talking to the victim like 10 or 15 minutes before. We ask the judicial authorities that called us in advance, so a few days at least, so that we have time to appoint a session with the victim in order to explain what's going to happen in court or in the police. And our starting point to work with the victim is how does he or she feel about what she's engaged or what the hearing that she has to perform. So I think that this task includes a lot of different things, and that's why in the directive it's mentioned in different rights. It's a task related to information and communication. It's also a task, as we have already said, about identifying protection needs. It's a dimension of support, mostly emotional support. So I think this is a complex right, and it's also very important not only the preparation stage, but also the follow-up stage. So after the hearing, to be there for the victim, because it can also be an opportunity to continue the support or even to start the support, because in most of the cases, we are accompanying victims by request of court. So these were not victims that were previously supported by us, but this is an opportunity to, on this follow-up, to continue to provide support to let's say, new victims for us. Thanks, Matt.
Thanks, Frederica. You talk about this accompaniment throughout, and I know at least under European legislation, they talk about the right to be accompanied in the initial contacts for the interview, for example. Do you think does it make such a big difference to victims and their enjoyment of rights? You think that victims should have the right to be accompanied by some sort of professional service throughout the whole of the proceedings? Frederica?
I definitely think so. And if you allow me just to read one sentence that is taken from an evaluation that was performed by one university about a new service that we have in prosecution services. And it's about victims being accompanied during their journey all along the criminal justice system. And this resulted from interviews with magistrates, so with prosecutors and with judges, where they say explicitly that they feel there's a more regular and collaborative posture on the part of victims. Their role is more active in the criminal process itself, resulting from its empowerment, reflecting in better access to law and justice, and the ability to emotionally stabilize the victim when necessary before court hearing is seen as another relevant contribution, including to the higher quality of the statements made by the victim. So the approach is, what are the advantages for the criminal justice system? But of course, we can see here also the advantages for victims as well.
Federico. Robin, I'll just come back to you, because in the Netherlands, there is this legal accompaniment. And if I understand rightly, that's Victim Support Netherlands who provides that. But you also have separately within Victim Support Netherlands, support workers who also accompany victims from an emotional support perspective. So you have this dual accompaniment. Can you say how you feel that impacts on victims in terms of their experience of the criminal proceedings, but also maybe picking up on Frederico's points, whether that enhances their ability to take part, to give evidence, and to enjoy their rights?
Well, I think the duality works a lot better. There's someone they can talk to for emotional support. And of course, our paralegals know a lot about emotional support as well. But I think the duality is very important, because victims are a part of a legal proceeding and they want to know a lot about the legal proceeding. So to have legal representation, even in the smaller cases, to me is very important. For example, with talks with the public prosecutor, which is a very important right for victims in the Netherlands. To have someone accompany them both for emotional support and legal representation is I think, a key in these situations. And in the Netherlands, of course, we had a lot of trouble with the COVID period as well, to have people enter in all the courtrooms. The first law basically said that victims can only be supported by one person, either someone for emotional support or someone as a legal representation, which of course was due to the number of people total that were allowed in courtrooms. And basically because of Victim Support Netherlands intervention, the law was changed to have someone legal representation and emotional support always present, because we in the Netherlands had some really heartbreaking cases where either victims themselves weren't allowed because of the restriction of people inside the courtroom, or they had to pick a certain family member, which is of course not the way it should be, at least for us.
Thank you for that, Robin. And I think this is potentially one of the routes that we could see others going in the future, and this greater involvement of victim support to facilitate legal representation. And we know that legal aid is very contentious, that there's a lot of pushback because of the costs. But I think what we're hearing here is how important some form of legal assistance and accompaniment can be to victims. No, in your case, your organization is based within the trial. Is it also involved in any of those aspects that Frederica mentioned, you know, the forensic examination or outside, or are there others who do that sort of thing? Or could you see that this is something which would be valuable to expand in Ireland itself?
Yeah, so our organization purely provides support at court. There are other organizations that accompany victims to, say, the interview with the police or forensic to the hospitals, if like the SATO units, with sexual assault treatment units in the hospital. So they provide that specialist support. And then some of the organizations have that. And then if the case gets to trial, they provide the court accompaniment. So they work alongside us. But some will refer into us if the case gets to court for court accompaniment. So we're not involved at any stage prior to the trial or post-trial, but we refer, excuse me, or organizations refer into us, or if, say, the victim, when the trial is finished and we have no contact with them, we will refer them on if they need that extra post-trial support.
Thank you, Dimple. I see we've got 1 minute left. It's more of an open question. Just picking up on the point on protection measures, I think both in the trial, but maybe also starting to look outside of the trial. Something that Victim Support Europe has been saying is that we need across Europe more harmonization on the types of measures that are available within courts to protect victims and outside of court, restraining orders and other forms of protection. Does anyone have any views on whether in their country you feel that the protection orders are sufficiently available, the types of measures are available, or is this something where you've seen others doing it better, some improvements could be made? Does anyone want to have a final comment on that?
I can take the final word. I think the EU directive basically has a very good legal framework for protection measures. There's of course the closing of criminal proceedings that should be available in every country, not just based on the suspect, but based on the needs of the victim, either in its entirety or during the victim impact statement, for example. In those cases, public and/or media should be removed from the courtroom. And then there's, of course, the non-disclosure of the victim's names, the right to avoid confrontation with the suspect. And of course, there's a lot of communication technologies that should be available for victims so they can be outside of the courtroom and not have to see the suspect. Of course, there should be waiting rooms, and there's a lot of very good protection measures. But I think for Victim Support Netherlands, one of the keywords has been privacy of victims from start to finish. And we've had a very good campaign that led to a new amendment of a law. We have the extension of victim rights law. An amendment for that was privacy for all victims of crimes, and that was basically because of our little book which says privacy for victims, facts or fiction, where all sorts of legal representation, officers from Victim Support Netherlands, even politicians, victim support lawyers, they were all interviewed and asked to, mention the importance of privacy from start to finish. And I think privacy leads to a lot of better protection measures during the entire criminal trial.
Thank you, Robin. That's a really good point. Unfortunately, we don't have time to explore it more. I know that in the Netherlands, you spent a huge amount of time looking at creating a new victim file, which was separate to the defense file, exactly to protect privacy. And I think as a direct result of the needs assessment, creation of a needs assessment as well. So that's an extremely important point. We've unfortunately run out of time now. I want to thank all four of you for a really interesting introduction to some of the issues. I think that there's a lot to think about, certainly around the concepts of accompaniment, how we can prepare victims beforehand, the cooperation between state actors and NGOs, and clearly there's a move towards seeing how both of those actors working together are the best solutions when it comes to helping victims participate safely within the criminal proceedings. So thank you to all four of you. I believe some of you will be around after lunch as well. People will be putting their chat questions in there, so please feel free to keep asking those questions. We are going to go to lunch now. We'll be coming back in 1 hour, which is 2:30 Central European time, and we will continue this discussion, moving back to what Robin said around communication, where we talk about effective communication, before we hear something about that really important priority around training of different practitioners. So thank you to all of our speakers this afternoon. It's been extremely interesting, and we will see you in an hour's time. Thank you very much. We are now moving on to the next sessions, where we continue these discussions around supporting victims within the criminal proceedings. We heard this morning from one victim of crime. We've heard about different groups of victims and the way that we can help victims within proceedings. We have two very special speakers now, who I've had the pleasure to meet on different occasions, and who I'm very happy will be speaking today. They're going to give a little bit about their experiences as victims of terrorism over the last years. We're going to hear from Philippe Vandenberg, who was a victim at the Brussels-Zaventem airport attack, and he was actually one of the first on the scene helping victims. We'll also hear from Florian Yehin. Sorry, Florian, I always pronounce that wrong, who lost his father in the Bamako attack. So I think, is it Philippe now, I believe, that's starting first? Thank you. Over to you then, Philippe.
Thank you indeed. Thank you, Levent. You heard me?
Yes, all good.
Okay, thank you. So I will share the next 15 minutes with Florian Geron as civil party in a terrorist case. One is for foreign countries, a trial that took place in a foreign country, and myself, I'm involved in the next trial in Belgium. It is planned for the next year. So thank you, Levent, for inviting us. I am victim of a terrorist attack as I was working at the Brussels airport on March 22 of 2016. I was involved as first responder. after the bombing, just after the bombing, and before the rescue arrives, I was on scene and trying to save lives. My psychological health has been severely affected, and I suffer from post-traumatic stress disease. I spent 2 months in a clinic specialized for soldiers and war trauma. So my first contact with the justice, I have to say that it's very chaotic because I was totally alone. Nobody helped me at the airport on my works, and I was totally alone in the dark. Despite the fact that I submitted a form for working accident, I got no reply from the Human Resource Department or from the legal department of the airport, and I didn't know what to do. So 3 months after the event, I met the Parliamentary Commission, the Inquiry Commission from the Parliamentary. They visit the airport on the first day of their work. At this moment, I read in the press that the Belgium Justice Department has a commission aiming and helping the victims of violence. So I searched on the web, and surprisingly, I discovered the full name of the commission that was for helping the victim of intentional act of violence and occasional rescuers. So I say, oh, that's me. I don't know what I didn't know at this moment that I was victim. I didn't know what to do. So from this moment, I was able to know what to do regarding the justice. The first step was to go to the police, of course, to be declared as injured party. And then the process started. I could meet the judge to be constituted as civil party. And then I have to say that this contact with the justice really saved my life, because before I was totally alone, under-recognized, rejected by the insurance company and by my own company. The Prime Minister never replied to the mails. My city mayor never replied to the mails, and so on. So from this moment, I know that the only official organization that worked for the victim was in fact the justice, so the prosecutor at this moment. And beside, of course, the King's secretary who replied to a mail, I have the feeling that it was really the only institution that can take the victim into consideration just by being civil party. From the legislation point of view, what's happened in Belgium, we got an audition from the Parliamentary Commission, thanks to the Victim Association of Europe. And that hearing, that audition have a great impact, a major impact in the press, and revealed that the victim were completely abandoned. So later, so we are now 1 year after the terrorist attack, we began to have a first law to help the victim. So the Belgium decided to give a statute to the victim similar to the victim of war victims, and 1 year later they extend this law to be also applicable to non-Belgian victim of terrorist attack in Belgium. So that's a major step. And then I continue to be very involved in every step of the justice procedures. The public prosecutor organized 2 meetings with the victim to explain the procedures and what is in the file. And then at each step of the procedure, we are invited and we have access to the file. And from this moment, I personally begin to follow all the steps and all the trial, and I participate to several trials against the terrorists. So the first trial was about Salah Abdeslam and the shooting in Brussels after the terrorist attack in Paris. There is a shooting in Brussels with involving Salah Abdeslam, and then we have also a major trial an ASIS course in Belgium about the Jewish Museum attack. And then also the ASIS course in Paris goes against jihadist women. So I try to follow this kind of trial to be prepared for the next year. I also be involved in the process to participate and to help the victims that are involved in the Ramblas terrorist attack in Spain. So that's I also try to follow the course at the Charlie Hebdo trial in Paris. And then today I sometimes go to Paris to follow the Paris attack terrorist, the trial, the ASIS course in Paris. One of the points I have to insist on is that we have some new law that help in helping the victims. And there's new rule exists now, but of course, in some case, the victim are facing a major problem with these new rules because they don't apply to the victim. I mean, the new rules applies to the future victims, of course. That's really dramatic for us because in the press and in the public, everybody see there's a new law for the victims, but in fact, this law does not apply to the current victim. It's only for the future. That's a major problem. That's a major concern for us. Nevertheless, we are happy there is new rules and new measure to help the victims. And that's what I want to note. One of the major problems for the victim is also to access the difficulty to access the case. So access the trial, I mean accessing the file because it's a huge file. In Brussels, we have 60,000 pages of file in the file. And as civil party, it's difficult to access. We have only access at certain moment in the procedures for a limited number of days. And of course, it's very difficult to read all these pages. And also, it's really, really difficult to pay lawyers during months to be able to read the file. That's the major concern I have. On the other hand, we have help from the region to access to as we go in the courts. We have people who are helping the victim, but that's not a follow-up. I mean, it's really helping at the moment of the session, but otherwise there is no organization that can help the victim from the moment the terrorist attack occurs. We have no more support. We have no support, and we only have the support of the other victims. In fact, other victims. So the associations can help the victim. That's what I want to say. And I will thank you, and I will give the mic to Florian Jehan. Florian Jehan, pardon. Florian.
Thank you very much, Philippe. Hello, everyone. Thank you for inviting me to this conference. So quickly, my name is Florian Jehan. I'm a 22 years old engineering student. And I lost my father in a terrorist attack in 2015 in Bamako at the Radisson Blu Hotel. So what I'm going to do today, I'm going to give you a few examples of, from my point of view, what went wrong in terms of psychological support and judicial support in the past 6 years, and give some advices on how I would improve it for future victims. So directly after the attack, my mother was willing to receive psychological support from the police or the judicial system, but it was simply not available. She had to wait for 1 month and then go to the other side of the city to get support. It was 1 week after the Paris attacks, so she obviously didn't want to take the subway. She wanted to stay home, not be stressed out too much. So the judicial system was not able to provide her the support she needed. So she decided to find a practitioner by herself. And it was not someone who was skilled to help victims of terrorism. So she received support, but I believe that she didn't receive the best support she could have received from someone who specialized in this kind of victims. And then another problem was that at the time there was no coverage for the cost for the victims of terrorism. So she was struggling between, I'm in an uncertain financial situation, but I would need to get support. And these things should not be mixed up. She shouldn't think about the money when she wants to take an appointment to see a psychologist. Later, when myself, I felt that I needed psychological support, I chose a practitioner myself, no problem on this side. But the coverage of the cost was limited to a certain number of appointments per year. And at some point, my mother told me, okay, Florian, you need to go to less appointments because we are in an uncertain financial situation. I don't know if I'm be able to pay for these appointments. And we had a really heated argument about that because from my point of view, it has nothing to do with, my computer tells me that my internet connection is bad. So if you don't hear me.
I can hear you, it's fine.
Okay, nice. So we had a heated argument because for me, I was going to as much as appointments as I wanted to go because it was my support and money had nothing to do with that. So it brought a lot of stress inside the house because of money to get support. It should not be the case. Now, as Philippe said, the law have changed in Belgium. So now there is coverage, but at the time it was not the case and it was really problematic, honestly. I would say that from our point of view, the major problem was communication. So obviously it happened in Mali. So the cooperation between the Belgian authorities and the Malian authorities is not the best. So it's normal that we don't always get information quickly, but it was always very difficult even to get someone on the phone, to get an appointment, to know what happens. And it happened a few times that we discovered information in the press before receiving official information from the authorities. And obviously, from our point of view, we are waiting for meetings for a few months, and we just get information from the press. We feel like our case is not important. We feel like the state is abandoning us. And what is surprising is that in the end, so last year there was a trial in VSE Conference in Brussels, and I discovered how much was done by the authorities. So it's not that nothing was done for us. It's just that we didn't receive the communication we needed about it. We wanted to be more informed. We wanted to know that things were happening. And then I have another example on the judicial system, is that at some point we had to go to court with the insurance companies because, as Philippe said, almost all insurance companies make problems with victims of terrorism. And when we started the procedure, at the time, there was no financial support for the victims. It means that we had the chance to be able to pay the bills of the lawyers, but some victims would not even have been able to defend their rights in justice because there is no financial support for these actions. And this is really problematic also. So in the end, the law changed in Belgium, and there is a partial support, partial coverage of the legal fees when you go to justice, when you're a victim of terrorism. It's how it should be. The coverage should be higher because we still had to pay tens of thousands of euros of legal fees. But supporting the legal actions of the victim in justice is really important to me. So based on these examples, I would give two advices to you. The first is communicate with victims, be available to give them information on what is happening, the investigation, the delays that can happen also, especially if it happened abroad, because I have no way to communicate with the Malian authorities myself. Then more on the psychological support. It should be quick, it should be free, it should be close to the victim's home, and it should be given by skilled people for terror victims. And honestly, we lacked the 4 elements. None of them. Then, so as you may know, Philippe and I are members of Europe. So it's the Belgian Association of the Victims of Terrorism. And I think I can safely say that all victims find there a safe place for them, a place to meet, a place to just spend some time, and to be with people who understand what we lived. So I would think that these associations should be supported and should be funded because it's a safe place for victims. And I also think that they should be able to provide psychological support to the victims, because currently it's not easy for them to do that. And then finally, more on state level, directly after the attacks, psychological support should be directly present. There should be no 1 month waiting list whatsoever. And also financial support should be present, because after such an attack, there is a lot of stress, especially, for example, for my mother who lost her husband. And money should not be an additional problem in that. There is already so much problems to deal with that it should not be the problem. And finally, simplify procedures. They tried to do it in Belgium. Honestly, they failed. There should be only one contact person to the authorities, give all the information, to get all the information, so that life is really easier for victims. So these are my advice, and thank you for listening to me.
Florian and Philippe, thank you so much for those interventions. I think that there's so many interconnections with what we heard earlier from Nina and from others. Certainly there's this interconnection between support and justice, and the critical role that support plays in actually helping victims participate in justice and criminal proceedings. There's clearly something around where you have rights as a victim, the importance of having some form of legal assistance to actually enforce those rights and to enjoy those rights, and the idea that victims have thousands upon thousands of euros to actually employ a lawyer is no more true than it is for defendants who have free legal assistance. So there's clearly, we see that not just across the situation for victims of terrorism, but for other victims as well. Interestingly, the Combating Terrorism Directive, EU directive, says that psychological support should be available free of charge for as long as needed. I think the question is that the reality today? We have been working with the European Commission, helping them run the European Centre of Expertise for Victims of Terrorism. We know there's lots of progress, but we know that there's a lot more to do. So I think that what you said just indicates some of the ways in which we need to improve in the field, not just for victims of terrorism, but across all areas as well. So thank you to both of you for that. And this is where we're now going to move on to. I have the great pleasure of presenting Jérôme Moreau, who is working in France Victim, but who's also the Vice President of Victim Support Europe. So I will quickly introduce him and allow him to start. So Jérôme has been President of the Victim Support Association for Association Nives d'aide aux victimes d'infraction. Sorry to all the French people for my accent, that is. Since 2003, and is the Vice President of both France Victim and Victim Support Europe. He's worked for 15 years as a parliamentary collaborator to a Member of Parliament for the 1st District of Nièvre. In 2020, he became Director of 3 departments of the Association des Paralyses de France, which is France Handicap, and he's therefore working for the most important French association for the defense and representation of people with disabilities and their families. And Jérôme, he's going to talk a little bit about a pilot project on multi-agency working. Over to you, Jérôme.
Thank you, Levent. Good afternoon, everyone. It is a great pleasure to see and to meet you all and to be online at this symposium. As Vice President of Victim Support Europe, I'm very pleased to present a new project that I am working on at the moment. When Levent asked me to speak here, I was not sure, in fact, the subject was perfect, but if we are looking for an example of self-justice, I think one of the most innovative point of view is through a local issue. First, I want to apologize for my accent and my bad English, but everybody knows how we learn English in France. There is only Pauline who speaks this language perfectly in the Federation, so be indulgent. I'm very glad to speak to you about a new project to help and support victims in the department of Nièvre, a small region in the center of France. A new center to help and support victims a new path. I am president of an association, a small association, in fact, with 7 permanent staff. It is a small team with a small budget. We have imagined a new pathway for victims because in my everyday job working with the disabled, it is obligatory to provide them with a seamless pathway of help and support, making sure disabled people have a permanent home and are not continually being moved from one place to another. This has been obligatory since 2005, when a very important law was passed. It is a new path and a new vision for the disabled. And I want to reproduce this system for victims, and we are working on this at the moment. In fact, I manage this victims association in an era where several difficulties exist. Firstly, we do not have any doctors who can perform the legal medical examinations, and it is a real problem to collect evidence for the investigation. In France, there is a lack of forensic pathologists in half of the department. In France, in order to prosecute an offender, the victim must have a medical certificate giving them a minimum of 8 days sick leave from work. This is a legal obligation. However, the injuries must be certified the day the doctor sees the victims, and the longer the examination is postponed, the less the injuries will be obvious. Secondly, victims have to see different people during the investigations: doctors, police officers, prosecutors, judges, social workers, lawyers, teams from victims association, psychologists, and sometimes psychiatrists. All of these professionals work in different places, and victims have to go to their offices. It is a real difficulty for them to go from place to place. Thirdly, a specific process to listen to children exists. A special room called Salle Mélanie, a room where there is an officer with a child with toys, and behind this room, another person such as a psychologist and another officer can follow the audition through a tinted glass windows. The project is to create a victim help and support center in which there is a more appropriate and benevolent pathway. The project includes 2 steps for the new center that I built. First of all, in the 4 hospitals in the Nièvre, all injured people will be guided towards the medical legal unit. Each department and each hospital practitioner must refer victims to the medical legal unit in order to have a single place of support and observation. To achieve this, training will be organized and protocols will be established. This is the first step of support and the first contact with the victims. I am convinced that most of the people who are victims of an offense go to hospital in France. The goal is to open the medical unit every day, even if doctors are not available all the time. Secondly, victims will be quickly taken to the Victim Assistance Center to be supported and helped in a multidisciplinary way, the new Victim Support Center. The interest lies in the fact that no victims remain alone without solution to their problem, without help. They should be certain that they can benefit from a set of services which will help them to overcome the effect of the offense. So, what can be found in this Victim Support Center? It is actually a house dedicated to the reception of victims and in which there will be different departments. In fact, there is various services which will help victims in all aspects of the procedure and support them during the trial, helping to provide them with an answer. In the first place, there is a transfer of all the associative services, receptionists, lawyers, psychologists, social workers, and specifically for us, a sophrologist. As a reminder, these services constitute the minimum base of assistance to people that the French Ministry of Justice requires for the approval of associations. This Victim Support Center will also be dedicated to child victims and mainly those who have suffered sexual crimes and sexual attacks. Today, in France, an enormous amount of work has already been done and will have to be done for them because we are discovering the extent of the criminal offenses which are increasingly reported. We think that over 500,000 children have been raped in their first 18 years of life in the Catholic Church. A specific and special commission has been set up called the Independent Commission on Incest and Sexual Violence Against Children, and their members are working on different rules and proposals to help and support these children. And this center is one possible solution. Therefore, we want young victims to be able to find all the services that can link to their care in the same place, thus reducing the legal and the expert assessment processes. There will be a set of devices which is exceptional, as it is a first in France. Everything will be done on the same technical platform in this center. There will be a gendarmerie brigade, a section of the French police, specially assigned to the problems of domestic violence and violence against minors. The most important innovation lies in the presence of these police forces who will have investigative powers, the possibility to do interviews and examination throughout the Nièvre, refer to the prosecutor or the examining magistrate, have a real investigative structure with officers and agents specializing in the field of domestic violence. We will also have a facility dog, Ushi, his name, arrived a year ago and is now dedicating to young victims throughout the procedure. It is a very good experience to have the support dog. It is the third one in France after Cahors and Strasbourg. In addition, psychological and psychiatric expertise will take place in a specific room in the center with the possibility of having help from several experienced people. A specific interview room known as Salle Melanie room will also be built and will be used for interviews of minors. It is a real step towards people being well treated because the condition of investigation will finally be secure and reassuring. I hope judges will come in this center to interview children. Two associations will come to hold appointments there too. The association dealing with violence against women and the Association for the Protection of Disabled and Elderly People. These two associations have been working with me for several months to build this project and try to convince the public authorities, which is the most difficult element. Finally, the Regional Service of Restorative Justice will be settled in this house. I think there is an emergency to protect all the victims without consideration of the type of crime. To conclude, I can say this project is being developed at the moment, and I hope that the inauguration will take place in 2 or 3 months. For the first time in France, a private association will have an investigative structure on the premises with real powers of access to procedure, orientation toward services. It will have expert assessment services and will be able to collaborate instantly with the member of the association. I think this is one of the models of the pathway for the victims that should be encouraged. However, this project will need to be assessed after years to highlight what works and correct errors. In this assessment, it will be necessary for the victims to be able to express their feeling. It will also be necessary to listen to the experts, the police forces, and the members of the association. I also think we will have to be vigilant on ethics and the rule for transmitting information. A special person, an ethics officer, should be taken on. The interest is to imagine to each victim can find what they need as quickly as possible and in the shortest possible time after the offense. The philosophy behind this project is to have a new vision of the victim path with no other consideration than the interest of victim. Founding a new course for the victim must also obey a clear and ambitious guideline, that of a renewal of the consideration of secondary victimization and the difficulties of reliving or re-experiencing the crime they have suffered. Finding the will to build a reception center for victims of offenses with many partners constitute a considerable challenge which goes beyond people and poses the problem of safe justice, a justice that acts and defines people's fundamental rights. William Hazlitt said, to conclude, where there is a will, there is a way. And I can say for victims, we must all have the will to show them the way to recovery. Thank you very much for your attention.
Thank you so much, Jérôme, and thank you for telling us about this, I would say, visionary project. I think we see more and more the acceptance of multi-agency solutions for specific groups of victims, for the most vulnerable, for children, multi-agency risk assessment centers for domestic violence, sexual assault referral centers in hospitals. So we see those, but you're taking it this one step further and saying, perhaps this is the solution for all victims, and bringing multiple services in there. We heard this morning from Nina the problems of getting medical forensic examinations in time and the impact that's had on her. So there's clearly a demand and a need, and we really hope you have great success with this project, and hopefully we'll see something like this coming out in other countries as well. I think what you said at the end about evaluation is critical. We shouldn't assume what we think is right. We should check it, improve it constantly, and see how we can move forward all the time. So thank you to Jérôme for that fascinating presentation. We'll now move on to our next speaker. We're really looking at the different parts of the justice process and the different actors involved. And I now have the great pleasure of introducing Monica Martí Garcia, who is coming from the European Judicial Training Network. And again, like we said before, we saw how all of us consider the importance of training. So it's a great pleasure to welcome Monica. She's responsible for criminal justice training activities within the European Judicial Training Network's Secretariat. She focuses in particular on judicial training in the field of the European Investigation Order, economic crimes, asset recovery and confiscation, procedural rights, victims' rights, and the EPPO trainings as well. Monica is a former lawyer, and in the past she worked in the European institutions and international law firms in Brussels, Madrid, and Boston. So it's over to you, Monica. Thank you.
Thank you. Thank you very much. I think I have to share my screen. So here we are.
Perfect, that's working.
Is working?
Yeah.
Okay, thank you. Thank you very much to Victim Support Europe for this opportunity to give to the European Judicial Training Network to inform you about our training offers for the judiciary. I would like to say some words about the GTN, about also our internal body in charge of the design, concept, and implementation and monitoring of the criminal justice activities. A specific training is assessment in terms of the victim rights training and our EGTN actions on victim rights in order to train the judiciary. EGTN is a non-profit international organization. It was founded in 2000, and we support the interests of more than 1,120,000 European judges, prosecutors, and trainers. EGTN develops training standards and curricula, coordinates judicial training, changes programs, and fosters cooperation between national training bodies. We are the only body to gather together all the training judicial schools and training national training institutions, even Ministry of Justice of the member states. And we have also a collaborative partnership with more or less more than 25 partners organizations. We have trained judiciary in the figures that you see. Of course, in 2020, due to the pandemic, we have to switch to from face-to-face to online, and now we are moving, if the pandemic allows, to move swiftly to face-to-face. One important step in EGTN is that in this year, we integrate court staff and training providers in the activity of the network, of our network, meaning that we will have also interest of the court staff in training on victim rights. This is our internal body in charge of the training of the judiciary in criminal justice. This is our members. As you see, is a widespread EU body which encompass Ministry of Justice and Office of Prosecutor General, prosecution offices, and national training institutions of the different member states. In 2012, the European Union adopted the legislation and to ensure that victims of crimes can rely on the same level of protection. This is the Directive 2012. And as you know very well, training is foreseen in recitals and articles of the directive. In this regard, in the GTN, we follow a path of identification of training needs of the judiciary, specifically in victim rights. We realize that there is insufficient training of practitioners at EU level on victim rights and not a sufficient knowledge of the directive. We consider that it was necessary to enhance knowledge and come up guidelines to better practically and comprehensively approach victims in the EU. We were aware the need to share experiences and best practices among the EU judiciary and, of course, practical knowledge of practitioners in order to improve the rights of all victims of crime. So several actions were foreseen, and then we started in 2019 December with the training aiming at providing knowledge and come up guidelines on how to better practically or comprehensively approach victims in the EU, taking into consideration the context of the events, crisis management, and the long course during the procedure. It was focused mainly on victims of collective accidents, terrorist attacks, and disasters. We had also, so this was our first training on victim rights at EU level, monitored and implemented by the EGTN. And then in this year, in 21, we have just had a recent webinar on victim rights of terrorist attacks. We presented, we tried to share knowledge and best practices presenting the protection of victims in France and Belgium in regard to the EU framework, efficient communication of the judicial authority with victims of terrorist attacks, cooperation with victims of terrorist attacks when they come from another country, and compensation. The idea here was share knowledge about France and Belgium and try to share this the approach with other judges and prosecutors of the EU. Our upcoming training next week will be in Brussels, and this training is focused on those vulnerable victims who require targeted and integrated support and protection, victims of domestic violence, child sex abuse, and gender-based violence. For 2022, based upon the EU strategy on victims' rights, you know, the Commission focus on training activities that effectively reach actors who are in contact with victims, means judicial authorities, judicial staff, lawyers, prosecutors, court staff, prison and probation staff. And in this regard, the Commission will strengthen its cooperation with EGTN. And then we decided to more focus on special types of victims through a series of webinars, and so targeted group or judges, prosecutors, and court staff, and victims of hate crimes will be the first webinar with the idea of protecting citizens against racism, homophobia, transphobia, and sexism. It will be in March. The second will be, again, the protection of victims of terrorism in the EU in practice. And a third webinar based upon the restitution of criminal assets, offenders compensation, and state compensation, and maybe also victims of cyber criminality. Again, we will have a second round of seminars on victim rights in the EU in practice, based upon also violence against women and children, And the idea also based upon the evaluation of this first seminar, we will maybe enlarge the scope or will be more targeted. This is something that we will have to do, of course, internally. I propose myself not to be very long in this presentation. So just to give you a panorama of what we do and what we do for the judiciary. And also, as a conclusion, I heard today many times training in different matters. We hope that during the discussion we can have some ideas that we can share, and also I can share within the EGTN.
Thank you so much, Monica. I saw a question there asking if anyone can take part in this training. I suspect it's limited to the judiciary and I guess the prosecution as well. But perhaps a follow-up question, maybe you can say a little bit about how you organize that training. Is it something that's provided by EJTM practitioners? Do you work with civil society organizations to develop it? Who is it that organizes it?
Yeah. Well, basically, our organization is based upon different bodies. And here we have the Criminal Justice Working Group, where we have 16 member states represented. And we, inside this group, we divide our let's say everybody has to do a work. And we have, let's say, judges or prosecutors in charge of the training. So we have a special judge or prosecutor in charge of a specific training. And then we have a pool of experts, and sometimes we also call other organizations. This is the case, for example, for the upcoming seminar. People from the organization will be presenting Victim Support Europe, as also the European Network of Victim Rights. And also, as I said in my presentation, there is a point of practical knowledge of approach judges and prosecutors on victims, and also our training are also approach on a practical approach for the practitioners based upon cases scenarios, but real cases where we can discuss the questions, what we can discuss which is the procedures in the member states, where we can discuss best practices, when we can discuss sharing of knowledge between the different legal systems, because we cannot oblige that we have 27 different legal systems, and then it is maybe necessary to have a comprehensive approach, a coherent approach, and let's say some common standards as the Victims' Rights Directive provides, but also in the field with people working with the victims in the court of the criminal proceedings. Thank
you, Monica. I think it's extremely important to see the EJTN placing so much focus on victims, and Victim Support Europe and others have set up their own training academies. We will have next year training on empathy and effective communication, and I really see that there are some great opportunities there for collaboration and working together. So thank you for that, Monica.
Thank you very much, Leonard.
Thank you, Monica.
Lev, you're on mute.
Sorry. We now move over to another side of the justice process, which is focused on law enforcement. So we heard earlier from Helen Williams, who's a family liaison officer in the UK Police. I'm now extremely happy to welcome over Elizabeth Zintschitz, which is always difficult for me to say, but I'll get there eventually. There's a lot of testing names today. Who's head of sector in CEPOL, which is the European Police Training Academy, and she'll be able to give us some insights around the way that CEPOL works. She's been a program officer and training manager with CEPOL for 14 years, where she's been responsible for the portfolios on trafficking in human beings, fundamental rights, and hate crime in the context of training for law enforcement and judicial staff. She's also worked in the social sector in Austria, where she led a treatment and prevention center for children who had suffered sexual abuse and domestic violence. And prior to this, she worked as a psychotherapist for 15 years in private practice with a focus on victims of sexual abuse and persons with special needs and refugees. So Elizabeth has a huge amount of knowledge to offer to us, and I'll hand the floor to you now, Elizabeth. Thank you.
Thank you very much, Liv. And yes, my name is really impossible. I lived 9 years in the UK and nobody there ever managed. So I'm going to share my PowerPoint presentation in the meantime, but you do not have to, just a second. I just have to see which screen because I have two screens here. There. So you don't have to feel bad about not being able to say. That's what I wanted to say. All right. Thank you very much. I hope it's visible in a good manner. And I'm just trying to find the first slide. So my PowerPoint presentation is divided in two sections because I want to introduce you briefly to CEPOL for those who don't know, who are not familiar with this agency. And that will just be a few slides. And then afterwards, I will go more into the topic on training for law enforcement on victims matters. I recently attended a train the trainers course as an expert, but I also learned a little bit there, and it was a very useful session on how to make a PowerPoint presentation. So you will see a before and after in this PowerPoint presentation. If you're interested on YouTube, find a video called Preventing Death by PowerPoint. So hopefully my PowerPoint presentation will be interesting to you. CEPOL has a structure in which I'm not going to explain completely, but there is a training and research unit, and here you can see the different sectors that we work in. Just also to explain my position, I am part of the CEPOL knowledge centers, and then there is an impact and grant sector that deals with organized crime. Then we have the Cybercrime Academy, and we have an e-learning sector and an exchange research and analysis sector. CEPOL Knowledge Center sectors deals with counterterrorism and law enforcement cooperation and covers the portfolio on fundamental rights, which includes victim support as a subtopic. I'm not going into detail, I said, but I just want to explain to you that in these sectors, we, on the one hand, we develop training, so we design curricula, we design the programs, and we partly implement them, but we also cooperate with member states, with the police academies in the member states, and they can also organize our courses via a grant system, a grant application system. The e-learning sector supports e-learning, and we have different products and activities on that level. And then we also have a sector that deals with, that has an exchange program where police officers can visit each other for a week and see how they work, how the colleagues work in that other country on specific topics, and establish a network. And then we also have research and a training needs analysis unit in the sectors. Just quickly, the products that we have, they are on-site activities, so training in class, if you want, online courses, online modules for self-learning, also e-lessons for self-learning, they are shorter, and a lot of webinars, many webinars, and cyber bites, which are very short videos, and e-workshops where we have discussions with a small group of 10 people on a very specialized topic. So that is what we provide. The target audience you can see here, it's law enforcement officials and judicial staff, usually judges and prosecutors attend some of our courses there where it is really relevant. And I'm very happy to see Monica before me, because we have worked already together for quite a while, because there are specific courses where the EJTN sends people too. And of course, we don't provide basic training for judicial staff, but there where it concerns the cooperation between law enforcement and judicial staff, particularly those courses are very important, and this cooperation has worked very well. And then we also do an evaluation every year, of course, and for some courses we also have tests. We're still in the process of developing this. One of our aims is also networking and inviting other organizations from outside the EU or also outside the EU context, meaning that the Justice and Home Affairs Agency like Europol and Frontex. We also try now to work increasingly with NGOs, civil society, and so on, where possible. If confidential material is shared, that is of course not possible, but in webinars, for example, it's very easy. And we certainly have increased that over the years. So that is CEPOL in a nutshell. We are at the moment in Budapest. We were in the UK for a long time. And you heard that I have been with CEPOL for quite a while in the meantime. It's 16 years, I think now. And I have seen changes over the years and a lot of improvements. And one of the improvements I'm happy to tell you about is the fact that fundamental rights matters, or matters that are not directly related with crime investigation, for example, or operational plans, cooperation means, etc. They have increased enormously. I would say, on the one hand, the Commission has increased that focus, has put a strong emphasis in the last maybe 5 to 10 years. But I think it also comes from other sides, and certainly the death of a Black American citizen, Afro-American citizen, by a police officer has probably made visible how important it is to also address such issues. So yeah, I'm not sure if there's one reason for this, but I'm very happy about it because I have been in charge of this portfolio for a while, and in the beginning it was really a hard fight, while now it goes like a hot knife through the butter. And CEPOL has been quite active also outside of CEPOL with on this level. So in that sense, and I had wanted to say that at the beginning, of course, is that I'm very happy and very honored to have been invited to this conference and to speak here to you and present CEPOL and our activities a bit. That would only fit into what I said before, that there is already quite a development ongoing, and also this type of cooperation is getting better and better. So CEPOL has it even in its mandate that, it has in its mandate, of course, that we should support, develop, implement, and coordinate training for law enforcement officials. That is a fact. That is just our task. And it is training across the borders on cross-border topics. So organized crime, counterterrorism, but also many other topics that are related to that. Fundamental rights is never a national issue. It's a local, a regional, national, international issue. So the cross-border element is maybe not so important here. What is important is, of course, that the EU shares specific values, which are the basis also for our training, and several documents that we also include. But in the mandate, it says specifically that there is an emphasis on, there should be an emphasis on the protection of human rights and fundamental freedoms in that training. This has changed from the first Council decision establishing CEPOL to the regulation in 2016, which was an amendment of this first Council decision, and also included judicial staff as target group for our training, but it also included this in the mandate. So I think that is another big step. It's not that law enforcement experts are not interested in fundamental rights, but they are primarily focused, of course, on operational activities. So operations, investigations, methods, tools, analysis, etc. The second thing is, of course, that in some cases, fundamental rights are, well, not always easy to not remember, but implement, let's say, especially if you have to balance it with the need for violence, which of course is only used as much as necessary to establish order or to arrest somebody. But on the other hand, you have to think in the moment often, and then it's not always present. So fundamental rights training is also important in that sense, that people really have it present when they need it. I'm here talking also about police ethics, of course. Now, in the context of this development that CIPO has seen over the years, where fundamental rights and all the subtopics, and we'll get to that, come under, well, have increased, have received more and more attention. We have decided to establish an expert group on fundamental rights. This is only for 1 year, for the time being. It was this year, in fact, that it was established and worked. And their mandate is to draft a fundamental rights training strategy. So you can see here that there are some member states involved, individual experts, and some from the Commission and JHA agencies, Justice and Home Affairs agencies. And they have worked very hard on, first of all, proposing all the topics that need to be included in CIPO training. That doesn't mean on-site training necessarily in class, because we can only have a limited number of those, but we can also include it in webinars. We can draft online modules and e-lessons, etc. So just to make sure that we touch all the issues. And I can already tell you that it is not so easy to cover everything, because it becomes more and more every year. There are new proposals, new topics that are on the agenda of different groups. And I had an increase of, I think the webinars I did last year have been doubled in 2021. And now I already have more than the number that I had this year proposed to me for next year. So that we have to see how we can do that, because it's a matter of planning, human resources, and financial resources, of course.
Elizabeth,
now, yes?
I'm sorry, you have 5 minutes left for your presentation.
Yeah, thank you. I will continue with my... so what is the role of law enforcement in safe justice? And here I found four keywords: protection, interaction, transfer, and safeguards. Safeguards in proceedings. So protection in the sense of really maybe even prevention, but also protection in the very moment. Interaction with victims, which is not always so easy, because the public often thinks that police officers could be psychologists, which they are not. But of course, they have to know how to deal with victims in the instant, and then also know who to transfer them to for further support, and what safeguards in proceedings must be guaranteed. If I then look at the training needs, at the topics that we have, there is on the one hand legal needs, so legislation on victims' rights, knowledge on legal support, knowledge on how they can contribute to victim compensation, knowledge on the safeguards, specifically where it is vulnerable adults and minors in judicial proceedings, and then law enforcement officers as victims is also a topic to address. Duty of care is something, because especially in terrorist attacks, that can, of course, happen. Then on the psychological level, as I said, they cannot be psychologists, but they must understand at least the basics of trauma and re-traumatization or secondary victimization when interacting with victims. And that is what we consider or what we include in our training curricula. And then, of course, the multi-sector cooperation is highly important when they transfer the victims to the support agencies, institutions that are available, be it medical, be it psychological, be it for social support, be it for compensation, be it for judicial support, etc. We have the following, well, we offer the following learning opportunities. In on-site training, we address hate crime, and victim is a part of victim rights, and victims support is a part of that. Then we have one course this year for the first time on victim protection itself, dealing a lot with the interactive and the transfer, the support with other agencies. And then we have police ethics and management of diversity, which is a two-step course, and we've had that over more than 10 years already. In our online training, we have a module on hate crime, which is for self-learning, and e-lessons on the protection of victims of counterterrorism, which we had this year, and anti-Muslim hatred. And then we have a whole load of webinars. I have not listed them individually because there are too many. But of course, there is, on the one hand, the type of victim that is affected by crime directly, but there is also the type of victim that is affected by police not respecting fundamental rights. And also that is part of our training on fundamental rights as a basic. And in the exchange program, which I mentioned before, we send people to other countries, to colleagues, to see how they work with ethics, how they train ethics, how they deal with xenophobia and hate crime and other issues, so that they can, on the one hand, learn from good practice and also establish networks with other law enforcement officers. So I've come to the end of my talk. If you are interested to know more about what we're doing, but also if you're interested to contribute to a webinar, for example, as I said, I have a whole lot of topics next year and we'll be looking for experts. And especially when I organize webinars, I always try to combine, on the one hand, experts who work on a meta level, like NGOs or directly with victims in this case, but also then with law enforcement officers who can tell people from their daily work. So theory and practice together, so to say. My next webinar will, for example, be on mental health. On police working with people with mental health problems. And there we will have, on the one hand, Mental Health Europe as an overarching organization, and police officers who talk about their daily work. So this is how we set up our webinars. In the courses, there is a more theoretical approach with a lot of interactive work, exercises, and so on, so that we make sure that people work together and learn on the basis of practical exercises. So my details are here. If you would like to contact me for any reason, then I will be happy. And I thank you very much for your attention and for this opportunity to present CBO and its training efforts. Thank you so much.
Thank you very much, Elizabeth. I think, again, there's such a huge amount there to learn about the work of CEPOL, but also it's very inspiring to see how much you're now focused on victims' issues. I think everyone in VSE gets worried when I come to these conferences because I suddenly see lots of opportunities in the coming weeks and months. I can imagine a wonderful joint training with the EJTN, CEPOL and Victim Support Europe. So maybe that we can make that happen in the future.
Please come forward. I'll be looking for it.
We have plenty of ideas. We're working at the moment with the Ontario Policing in Canada on training. One of the pieces I think that we'd really love to see are the soft skills around effective communication and empathy, which really consolidates all of that work that you've been talking about. But I think that there's so much opportunity there for how police officers, prosecutors, judges can be trained. We had last year a presentation by a Spanish university. They've developed virtual reality training on empathy for hate crime, where police officers can really feel as if they're in the shoes of a person of a different color, for example. So there's so much there that I think is happening now, and this is really a moment when we can transform these ideas into real training programs for police, for prosecutors and judges. So thank you very much for that presentation.
You're welcome.
Thank you, Elizabeth.
Levent, you're on mute.
Before I forget, I have to say this now because I've missed it twice and I'm in big trouble. We were going to have a nice photo of the presenters and panelists. So before we go to the coffee break, I would ask all of those panelists and those who are able to switch on their cameras, if you'd be willing to put on your camera for a sort of group photo, which we'll use in our annual conference report, in our normal social media, etc., just to show how successful the conference has been. So if you're happy and willing to switch on your cameras, we'd be very delighted. And I think it's Sarah who will put it into a format where we can see everyone, and then they will take a photo. Sarah, are you going to let us know when you're in position? I don't know if you have to change the view or if you've got your view. I think we change our own views. Gallery. I can see lots of people there. Oh, Alexandra's just run off. There she is. Okay. So all those who
are fixing the light, I had light behind me. It was really awkward.
That's okay. You're looking beautiful. Okay. Sorry.
I need cigarettes.
We're all coming online. We'll take the photo in 10 seconds. There we go. There's Philippe. Okay, go for it, Sarah. Maybe a couple more. Perfect. Is that okay for you, Sarah? Thank you very much to all of the speakers who are in that group photo. We really appreciate it. We're just going to have our final coffee break. I know this is late in the day. Of course, normally everyone would be able to look forward to having some nice drinks and conversations together after the live conference. We don't have that, but please come back with your wines, beers, coffees, chocolates, biscuits, whatever it is. There's a fantastic final session after the coffee break. We'll be back at 16:55, so in 14 minutes time, for a final panel discussion, and that will be run by Suzanne van der Aar. So please come back for that. We look forward to seeing them. Thank you. Welcome back, everybody. I think that was my favorite song. If you spill your glass, we'll get another round. So here to that. I'm ready for my glass as soon as this is over. But before that, we have a fantastic final session. Deep appreciation to Suzanne, who organized this and has brought the speakers together. We're going to have 4 speakers talking about and discussing the future path for criminal justice systems and really looking at how we can ensure that that victims' needs are taken into account throughout the criminal proceedings. What does that mean for victim-centered justice systems? So we have Suzanne as a moderator. You can see her there. We also have Nicolette coming back and Monica. And we also have Sarbert who's speaking. We haven't introduced Sar, so I will do that just now. Sarbert is a researcher and trainer at the International Centre for Reproductive Health at Ghent University over here in Belgium. Her field of expertise is holistic care for victims of sexual violence, both in Belgium and in the global south. Together with Professor Keinart, she piloted the Belgian sexual assault care centres, and through her work, she explored motivations of victims of sexual violence to report to the police and their experience with the criminal justice system in Belgium. And we went over actually with a study visit with the Korean police, and that's an amazing centre that they have set up there. So it's great to have her on board as well. So Suzanne, I'm going to hand over to you, and I'm going to relax a bit and enjoy this one. Over to you.
Please do laugh, and please start taking your wine already. I mean, nobody's stopping at the moment. Thank you all and welcome to the final session of today's conference. Well, when we started organizing this panel session back when Omicron was still just a Greek letter, we had planned a truly interactive session for you with statements using multiple choice questions. And the idea was that we would ask the audience to stand up if you agreed with a certain statement and then sit down if you disagreed. That has changed, obviously. So instead, thanks to the technical support of Victim Support Europe, BEXOT in particular, we now have an online poll again. But please feel free to stand up and exercise a little bit. It's good for the blood flow and it keeps you awake and active, hopefully. Now, the four of us have developed a poll with 7 questions, but it's more a means to an end. What we would like to have with you is an interactive discussion. So yes, please, you can elaborate on the questions of the poll. You can elaborate on your answers. But if you want to, please feel free to also raise certain issues of your particular interest. I don't think we mind, you know, it's an open floor really. Because we've heard so many interesting things today, we couldn't capture all of that in only one poll. Now I've been told that some of us, they are able to join the discussions live, so we can have a live conversation. Unfortunately, some others can only react via the chat, but please do not let that restrain you from reacting. Please use that chat function because Ruth will then intervene and also share with us what is going on in the chat conversation room. Now, without further ado, I would like to ask BEXOT to display the first statement or proposition that we had developed. So, no, wait, I'll allow you some time to read through the question and the answers. And I don't know, BEXOT, if we have an idea of how many answers we have received already. Oh, wow. Still many more coming in. Well, again, we're twisting your arm here. So we're forcing you to choose one answer only. We're equally cruel as Lev was, Levin, previously. or 55. I'm going to give it 5 more seconds. So what is the most urgent barrier to safe justice? Do we want more laws, additional laws and regulations, perhaps? Do we finally want to tackle that imbalance between victim rights and defense rights? Is there a problem with implementation of the laws due to lack of finances? Or do we need to change the culture of the criminal justice system? I think we have a winner here, winner or loser, depends on how you see that. So I'm going to end this poll. Sorry? Maybe somebody's mic was still on. So the biggest problem, according to you, because finally you get to take the stage, is that there is a problem with the balance between victim rights and those of the defendant. Does somebody care to elaborate on that? Missing information, I see here in the chat. I think the biggest information or the biggest problem is missing information and understanding about EU law and human rights. In Germany, they don't understand these matters at all. So, Sandra Oeling, if I understand you correctly, what you're saying is information really is the problem, but that would relate perhaps then to training like we've seen earlier during this conference, Germany discriminates victims and the EU does nothing. And Lev says, I think there are lots of great practices, but these are consistent everywhere. So implementation is really important. Lev, I know you can talk, so maybe it's nicer to have this interactive discussion.
I was just going to add, sorry, I'm not supposed to keep speaking, but I say that, but at the same time, that 38% who talk about the balance between victims' rights and fair trials rights, that's really interesting to me. We're like quite cautious about getting into those questions, and we see doubts about questioning it, but this is reassuring that this is something we seem to have to talk about and really get into what are these problems. So that's really interesting to me.
Yeah.
I agree that I actually think that the four of them, sorry, Suzanne, I'm just jumping in here.
Please do.
Obviously, we had to choose between which one was the most important, and I was torn between B and D, but I opted for D in the end because I think that there are lots of rights that we aren't consistently applying. I think there are issues with training. I think there are issues with the balance of defendants' rights and the focus on defendants' rights over victims' rights. But one of the biggest things that I believe is the problem is the culture. And regardless of what country we're in, we can make improvements. But as long as we still have a culture that maybe focuses more on defendants' rights, then I think the practice of that, certainly within an adversarial system, is that you have a culture where there's one side pitted against the other. And what then happens is what we see certainly in Northern Ireland is the defence's role is to win, to get their client off on a case. And so many of the things that victims complain about come down to really basic human interaction. They're the soft skills, they're around dignity and respect. And that's shouldn't need a law. We all know how we like to be treated ourselves as human beings, and we all know how we would like our loved ones to be treated if they were a victim of crime in the court environment. But yet, for some reason, when it comes to victims and their experience of the criminal justice system, those expectations that we have of each other seems to go out the window, and we see things very much through a lens of whatever side of the argument that we're on. So for me, there's something around us all understanding that we're all human beings. And I think that culture piece is very hard to deal or to address, because laws and improvements still hasn't, whilst I think there's been a lot of improvement in terms of the treatment of victims in the last 20 years, I expect 20 years ago, people would have been talking about dignity and respect, and 20 years from then, and so today we're still talking about those issues.
Yeah. Thank you, Geraldine, for sharing that with us. The chat is exploding. Where to begin? There should be a presumption of victimization together with the presumption of innocence. I like that a lot. Alexandra, I'm not sure if you can comment on that live. Hello.
Hi. So yeah, I mean, it's actually something that there's been quite a lot of talk about it. Just for those who don't know me, Alexandra Ivankovic, Deputy Director of Victim Support Europe. And this I think follows also on some of the comments regarding human rights as victims' rights, and the entire body of human rights law that we have at the international level, European level, national level, etc., is built. Well, the core of it was built in the 50s and the 60s of the last century. And to be honest, I think that the political climate that we have now in Europe and globally, if someone proposed the European Convention on Human Rights now to be adopted, I don't think that would ever stand a chance, like a fighting chance to go anywhere far. So, we just have to hold on dearly to whatever we have, even though it's far from a perfect instrument. And then all these instruments, the European Convention, the UN covenants, etc., talk about presumption of innocence. And when they talk about rights at trial, most of it is focused around the offender, for a good reason, mind you, because back in the 50s and the 60s, that was what needed to be done after the experiences earlier in the century and in previous centuries, and like, you know, let's not go back to witch hunts and everything else. But now, you know, like, we came quite a long way in terms of the rights of the offender. And I'm sure if we were talking in a different forum, there would be arguments for yes, but we need to go further. But I will not go there. In this forum, I would say we have to bring victims to the same level. We were just talking yesterday in a workshop on safe justice on a paper that we're discussing. We need to have an equality of arms. And we always, in law, as lawyers, I'm a lawyer, obviously, we always talk about equality of arms. But I don't see that equality between the victim and the offender in the courtroom. And if we have the presumption of innocence, which obviously has a big role and far from anywhere we're trying to advocate for that to be brought into question, but there is a good case to be made for the presumption of victimization and for these two realities to coexist in a courtroom at the same time without actually jeopardizing each other, because you can still be a victim and you are a victim, as we heard from Nina this morning, a victim of terrible crime. She is a victim, regardless of the fact that for a number of years, no one knew who was her rapist. And then afterwards, there was no prosecution because on procedural grounds. That does not negate the fact that she was a victim. And this is what we need to establish, that you can be both. You can have both in the same space. You can be a victim even if there is no conviction, and you can have your presumption of victimization even while you're contesting a presumption of innocence in a courtroom. So it's a bit long, but I hope I got the message across.
I got your message across clearly. So yeah, thank you, Alexandra. There is a problem there, of course. So you rightfully say, you know, we have the presumption of innocence on the one hand and the presumption of victimization on the other. In day-to-day practice, you can see these two presumptions, well, at least be in a sort of difficult relation to one another. Take, for instance, making a victim impact statement. Depends perhaps on the time when you are allowed to make such a statement. But what I hear back from practice is quite often, okay, victims are allowed to make a victim impact statement or a victim statement of opinion before there's a final judgment on the guilt or innocence of the defendant. So how do we go about that? And some judges manage to work their way around that problem relatively easily, so without giving the defendant the idea that he or she has already been judged upon, but some struggle with that. So which words can you use? How can you express empathy towards the victim without, you know, trespassing the, the presumption of innocence? So in practice, it's a nitty-gritty work sometimes. The justice process is focusing on offenders and does not take into account and explore victims' various needs. Balint, can you comment on that? I'm not sure, I don't know who can speak or who has to remain silent.
I don't think they can speak.
Everyone can speak now, or?
I think it's still the panelists, but we have a technical limitation that only people registered as panelists can speak.
Okay, training that Sipol mentioned. Sandra's point on state power. I'm sorry, I missed that. Victim Support Malta agrees with Geraldine. So it's basically the culture that needs to change. Even organizations do not understand EU rights, EU conventions. Yes, thank you for that. I'm looking at the panelists, whether you want to contribute something or should we go to the next item on the poll perhaps?
Suzanne, just to let you know, I've been told that they're trying to give Balint access to speak. So
okay.
Let me just quickly ask, Annalise, have you managed to give Balint access?
Yes, if he unmutes himself, he should be able to intervene.
Now, I don't want to put anyone on the spot, so if Balint does not want to do it via audio, that's fine as well. I don't feel obliged to. That is also a very interesting proposition. Maybe EU rights have to become hardcore law instead of soft law.
I'll certainly say on that you see the change, but it's not the sole solution. But what you see, I think, in member states, it's where you have the combination that the law is put in place, that the right is there. It's accompanied by sanctions where it's not enforced, but then you have procedures, protocols, practices, training, and all the rest which accompany. But if you don't have one or the other, it's not an ideal situation. You can put all the practices in place, but where you don't have the protection of rights in law, then there is something which you don't have enough protection. It's not taken as seriously, I think. So that's important.
Oh. All right, let's move on to the next question. Beksat, could you introduce that? So again, the request to the audience is to vote. I'm spotting a unanimous decision here.
I'm very surprised, Suzanne.
3 opponents, so that could be an interesting discussion as well. I'm going to give it 5 more seconds approximately, and then we're going to close this. And I think we're complete. We're going to end the poll. And Saar, you developed this question. Would you like to elaborate on it a little bit?
Yes, thank you. Well, I think from the experience that we had in Belgium here with training police officers who are actually interviewing victims of sexual violence in sexual assault care centers, we actually do see from the evaluation that we have from victims that they strongly support such an initiative, and that the whole risk of secondary traumatization, re-victimization is really much diminished among victims. Interestingly enough, I think while the project that I worked on was the focus for victims of sexual violence, the police actually independently started to develop further initiatives to have other police officers also trained on trauma-informed interviewing skills, and wanted to set up actually specific teams for these more vulnerable victims to do also interviewing of victims of domestic violence, etc. So this training for us started to interview victims of sexual violence, but actually organically within the police, actually it had its effect on expanding, because they immediately saw also the interest not only for victims but also for the efficiency of the system, of having better hearings and so on. So of course I am putting a clear yes to that, and indeed the rest of the most people in the audience do the same thing, but it would be interesting to see a bit what are still the barriers to implement that.
Yeah. So it's very nice to hear, about this intrinsic motivation of the police to spread the word, so to speak. Typically, that really helps. I'm not sure if there, we had 3 opponents. Would they like to elaborate on why they disagreed? Is there anybody of those who can speak? If not, I'm afraid we'll have to stick to the chat function.
Maybe whilst you're waiting, I would just ask the question, why only vulnerable victims? Should not all victims be interviewed by trauma-informed specialists?
What do you think,
Suzanne,
or Geraldine?
Suzanne, just so you know, I think everyone has been given access to speak, so we may not be able to see you on your camera, but if you unmute yourself, if you want to speak, you should be able to intervene. If we get really rowdy, we'll have to mute everyone again, so don't all rush at once.
But
that's good to know.
Yeah. You could use the raise hand button as well if you want to speak.
Yeah.
Do you want me to comment on the question of why not for all victims? For sure. Yeah, I guess for me, I do think that indeed be specific only for victims of sexual violence. I think from my background, that is what I know. That is what I know best. This common intrusion for me as well, to see that there's a lot of similar challenges for other victims, people who are victim of other crimes. So definitely, yes, I think we should go for everybody to receive the best support from law enforcement as possible.
Because I think the point here is, well, one of the things that we're really pushing for, and I think is reflected in some of the difficulties of CEPOL, for example, is police are overwhelmed with how much they have to learn, procedural rules and all the rest. I think the more that you can incorporate certain forms of training into wider training on investigative techniques, on communication techniques, which benefit all aspects of their work, the better. So police are, we have community policing where police are working in communities. They're working with people with mental health issues. They're working with all sorts of people in different formats of conflict with law. They're working with victims and witnesses. And many of these people are in some ways traumatized. So this isn't only about benefiting our ability, or police officers' ability to communicate with victims. It's improving their ability to do their job across the board. And I think the more we can understand some of those factors, the more that you'll incorporate that thinking into the overall approach of police officers. And in a way, it's sort of, if you're talking about, for example, conflict resolution and conflict mitigation, where you're reducing the pressures and the anger within a situation, these are all skills which police officers need, and they are all similar in nature about understanding triggers, understanding the situation you're in, and learning how to understand people's motivations and communicate effectively. And that's just as relevant for victims. Sorry, Jerry.
Yeah, you're okay. I'm thinking in addition to that as well, you also understand when you learn about trauma-informed practice, about what the impact of trauma has on you as a practitioner. So obviously police officers are dealing with traumatic incidents and they can be affected by that. So understanding the impact of trauma on themselves will help with their own health and well-being, but also help enable them to better respond to individuals who are experiencing trauma.
Thank you. I saw you raise your hand, Nicolette.
Yeah, because I actually wanted to say exactly what Geraldine just said. But basically, I think the problem is really that, and well, basically with any training, is that it usually seems that the training is coming in as an extra additional something that doesn't really have to do with the job. And so you take it on as an extra burden. Whereas I think in this case, what we're saying that it's really an integrated and holistic part of the job and the development itself. So if we reconceptualize the trauma-informed approach as part of well-being in general in the profession, so as soon as you understand the impact of trauma on yourself or any sort of issue on yourself, then you can easier relate to the impact of trauma with the people you're interviewing, for example. And I also very much agree with the previous comment that I think in general, having knowledge on trauma and the impact of trauma would be relevant for all law enforcement officers who interview in general or who are just in the profession. So I would say even before entering the workforce, there should be training on this so that it doesn't become such an unknown sort of thing, but that it's part of the development from the beginning.
It's very important, this discussion. And so the reframing of the trauma-informed interviewing technique should form part of perhaps police academy or even prior to that, law or at law schools, who knows? Because it's applicable to more situations, also in dealing with suspects and their own safety and well-being. So thank you. Let's see. Oh, I'm afraid that the chat is exploding and I can't keep up with everything. Is there somehow that we can filter through these questions quickly?
Yeah, I can raise one for you if you like, Suzanne. We have a point here from Jamila, who I think brings up an important point, that outside of the police, there's a necessity to have general personnel that are trained in post-traumatic shock. but that one of the issues, she's used Belgium as a country example, is that psychologists specializing in PTSD are extremely rare, and there's hardly any, and access to them is very difficult.
Yeah. Sarah?
Well, yeah, I can add to that. I think indeed psychological support is indeed lacking with people who are trained. And then I saw this question of Levent as well on police receiving 2 weeks training. In Belgium, that is indeed a 2 weeks training for those people who are motivated and willing to work with victims of sexual violence, and their trauma is addressed. But indeed, and that's not part of the standard program of everybody. And I think as much as I agree, Anna, that it should be part of the basic training of everybody, we do see that, especially in bigger cities in Belgium for the police, there is a wish to actually specialize people because of their own motivation, because of a way to get further in the system. So it's a bit of a dilemma, I think, that on the one hand, specialization can really be highly valuable, whilst on the other hand, we do feel that everybody should be able to intervene and support victims.
Yes, thank you. And also to reiterate what was said before, police officers, criminal justice personnel, they are not psychologists. You know, they cannot give the true psychological need and support that is also needed. So if it's true that there are too few psychologists, psychiatrists specialized in PTSD, we have an entirely different problem. Lev?
Yeah, so I wanted to go back to the poll and the 40% view on defense rights versus, well, I don't know whether it's defense or fair trial rights. You've got me confused now, Suzanne. But that balance, and we've had a few conversations really about a specific issue, but maybe this reflects some of those concerns, and it's around procedural rules which get breached, defense right procedural rules which get breached, which results, for example, in acquittal. And there's sort of concern that we may be getting to this point where there are so many rules which police and prosecutors have to follow, and effectively, it's not become necessarily about guilt, but rather about, can you find some loophole where some small mistake has been made, and where actually you can get acquittal on that basis rather than on the facts of the case. And I think that might be the sort of example which raises concerns about where the balance is. And you know, the moment we introduce a victim right, it's like, well, the police are too busy, and yet on the other side, it's acceptable that there are so many other procedural rules on the defense right. So I wonder if that's part of what are the concerns that are being raised. And I don't know whether this is correct, if those procedural rules are resulting in acquittals, if it's justified that they result in acquittals, but that's some of the points that's been raised in conversations we've had.
Mm-hmm. Well, if I only look at the Netherlands, we see a tendency that seems to go in the opposite direction. Where there used to be acquittals relatively easily for breaking all sorts of procedural rules, we've definitely put a cap on that trend some time ago. So now you may get a reduction when it comes to the sentence, or it could be that the courts only acknowledge that certain rules have been breached, but that is it. What might be more concerning is that adding, all these layers, not only from a rights perspective, but also really complex. And you talked about, okay, we have training upon training upon training. It becomes really complex, and maybe that adds to the pressure people feel. Things are constantly changing, and can we keep up? If we also know that time and money and capacity is lacking, also from, in guaranteeing defense rights.
How did you get that change in the Netherlands?
I think mostly it was politically initiated, so people being displeased with these acquittals precisely. So in the Netherlands, there was a feeling that the courts were too lenient in general. And that translated in more, stricter policies, I think. And yeah, so it was more political change.
Judicial guidance on, is it like legislated for that if it's this type of procedural breach, a judge has a kind of range of options, or how do you solve that?
Yeah, we have in the laws, what we have in the criminal procedural code of criminal procedure, we have the outcomes, the possible outcomes that are available if certain rules are not adhered to. But this was typically something that was developed, I think, in case law. So we saw a gradual change in the courts and the way they addressed certain issues. Whereas previously, certain mistakes would have led to an acquittal. It changed gradually towards more lenient reactions, or more lenient in the sense that stricter towards the defendant, more lenient towards police and public prosecution service that made mistakes. Shall we go to the next item on the agenda? Backzots. Access to safe reporting for vulnerable victims. Oh, is it displayed? Should primarily be facilitated by the healthcare system or by the police. This is indeed a tough one. Twisting your arms again. Let's see, we have 27 out of 50 people present. I'm going to force you to speed up a little bit. So 5 more seconds. 5. Oh no, I think we more or less, we have it. And poll. Share results. This really is a tie. This really is a tie. Sarah, would you like to comment on this first, perhaps?
Yes, thank you. It was, of course, tough because we were forced to choose primarily or not. I think there's a big window of opportunity or a lot of chances still to be taken to actually improve reporting by facilitating aspect through health services or other care services. I see somebody added here in the chat that it's any other professional who comes in contact with victims that should be considered. And that's also strongly what I believe in. And I think, again, the example from the sexual assault care services in Belgium, we see that the holistic care that somebody needs, or the care is sometimes often the first entry point that people have with formal services, and that they can do a lot in just having the talk with the victim on do you want to file a complaint, yes or no. And in Belgium, we have the chance that the police is actually coming to the sexual assault care center, has an adapted space within the bubble of the center where the person feels safe and feels well and has trusted people around them. And that is actually an opportunity to ensure that more people feel okay to report and don't have to go through negative experiences of arriving at the police station and having to say at the reception why you are coming, and having to do an audition with other people who are even capable to hear what you're saying. So I think there's a window of opportunity, and I strongly believe in this multidisciplinary approach or interventions, as has also been already presented this afternoon by Jérôme, for example. So I think there's big chances to gain there.
Yeah. Initially, we had a third option, so both, and I think then everybody would have agreed, like, okay, we need both entrance options. In France, the vulnerable go to the hospital first, and I think the best system is that vulnerable victims can access the police in the health system. So yeah, it sounds like Jérôme agrees with you, Sarah, and you agree with Jérôme. This is a matter of coordination between services. If we do not have these specialized bubbles or these victim, how did you call those, Jérôme? So these one-stop shops. Do you think we have a problem with the coordination between the health care system and the police? When I talk in terms of referrals, for instance.
Yes, in France, it's difficult because the police, in fact, doesn't go to the emergency service and doesn't go to the hospital. And in fact, there is a new law who impose that the police could interview the victims in the hospital, in the emergency service, but actually it is impossible because first the police doesn't go because they have no time, and there is no coordination because the doctors and the emergency people didn't call the police, and it's a very important problem in France, because we have victims in the hospital, and the police says we don't know they are in the hospital. So there is a coordination problems, and we don't know how to resolve this difficulty.
Okay, thank you.
I am clear, but voilà.
Yeah, it was very clear, Jérôme. Thank you. I just got a private message that I need to keep track of the time, which I haven't. I apologize for that. Maybe we can go on with the fourth question then, Begzat. Thank you. So again, having to choose your primary answer. Currently, many gaps exist in ensuring safety for victims. Which of the following would need urgent attention in your country context? So now you only have to think of your country. Yeah, numbers are adding up. Half of the participants have answered. I'm going to give you 5 more seconds. 5, 4, 3, 2, 1. Thank you for answering this question. Well, we have a lot of supporters for the holistic individual assessment. Anybody care to elaborate on that, perhaps?
I'm thinking back to the discussion earlier today. I think you know, part of the problem with these individual needs assessments is police are sometimes too busy, or they don't have the procedures or the training. But on top of that, they're focused on just one aspect, but you need, you know, the support needs, you need multiple different forms of assessment to take place, but you need them to be doing that in collaboration with victim support. And I remember, so when I was in the commission, I prepared the Victims' Rights Directive, and I sat down with Mark Grunhausen to think about some of these rights, and we really had a long discussion about whether to introduce an individual needs assessment at all, and then whether that should incorporate a support aspect or not. And he was really concerned about expecting police officers to be able to do this, a needs assessment on support, because they weren't really in the right position. And this is why we have the directive as it is. But I think what we hear also is that there is a gap. There's something that needs to be resolved. I've heard lots of people say how important this needs assessment is, but it's not working perfectly. And on top of that, there's really something about connecting victims to support. And actually, I connect it also to the referral mechanisms. You need these together. I think we keep hearing about it today. It's the collaboration between support and justice and health, actually. It's the bridging of those, which is critical. And this is why, for example, we're working with the Estonian government in a project to develop referral mechanisms and understanding amongst hospital staff on identifying victimization, but then knowing what to do and how to support the victim and inform them and refer them. So I think these are all integrated issues. You can't handle this in a individualized process. You need this entire framework which is wrapping around the victim and which is supporting justice practitioners to do their job and supporting the support workers to do their job as well.
Yeah. Thanks. One of the, sorry, Nicolette.
I was the one who put that question forward, but actually now I have a follow-up question on that, because I would have put the holistic individual assessment as well, because for me, once that is done, then there kind of flows all the rest. So then you would have you would cover needs for accommodation and for protection and for any kind of basic needs. And in our research, we also found that this was very much lacking, that there would be an assessment of one thing, but not another. And essentially other needs were not covered, that then prevented people from reporting and to stay within the whole process. But then my question, because I actually also do understand that for police officers to do this kind of full scope of individual needs assessment, and indeed they might not be trained for that. So then what would be the place, or who would be that authority, or should there be again a sort of multi-agency cooperation in doing that, and how that would look like? That's still a question to me. So thoughts on that?
Geraldine, was it a raised hand or a raised finger?
It was me trying to get it was rather random. I suppose this one, the holistic needs assessment, is kind of where I opted on this one as well. And you will have heard from Peter earlier that there is a plan that has been adopted by our Criminal Justice Board, which would see Victim Support Northern Ireland set up a needs assessment service within the Victim and Witness Care Unit. Now, we've got that agreement, but we don't have the monies as yet, so the funding needs to come with it. But what it would mean is you would have a victim support worker who, once the police put the details onto their system, the police also work as part of the Victim and Witness Care Unit, the needs assessment officer would contact the victim, and that would be a triage process in terms of every victim would get a contact, but some would get a phone call, others would get a text message or a letter. And the needs assessment would look at the whole range of needs. What we find with the needs assessment that have been undertaken to date by both prosecution services but also police is that it's very much focused on what does the system need to make sure this victim has to keep them engaged in the criminal justice process, whereas what we're kind of advocating for is a needs assessment like what Lev's talking about, where we look at the broader psychosocial needs of victims as well, needs for accommodation, needs for safety, you know, those very immediate pieces, but also that it would then be repeated at key stages throughout their journey. So if there was a decision to prosecute or a decision not to prosecute, that the needs assessment is revisited. And it's not that the victim has to keep them updated, has to go through the whole thing again, that it's just checking in on, and that the key to the success, and as I say, it's only an idea at this stage, it's not in practice, but the key to it from our perspective would be that the individual conducting the needs assessment should be doing it more in a conversational style. It's not a right question 14, question 15, question 16. Victims feel like they're being scrutinized. That's where the skill set and the time is needed, and that's where I think police officers, prosecutors, their skill set is really focused in different areas, and they don't necessarily have the time to do that. So I think the the dream is having a multi-agency working together, and also those victim support agencies are able to be aware of other organisations who can provide support, who they can refer the victim to for to help meet those needs.
Oh, sounds like a very promising practice, Geraldine, with a special needs assessment officer. In the Netherlands, it's the generalist police officers who have to do this. And indeed, the fear was that it would be reduced to just ticking the necessary boxes. How it works in practice, we don't know just yet. I'm very curious to find out. However, with an eye on the time, there's not too much time left, but maybe we can do a final question, see where that takes us. So perhaps one more, Beksot? Yes. So yeah, about the vulnerability label, should we be using that still, or with more caution perhaps? Almost half of the group has voted. I'm giving it 5 more seconds. 5, 4, 3, 2, 1. There may not be sufficient time to discuss this in depth, but at least we have the results of the poll. Oh, failed to share poll. Another poll has started. Can you see the outcome, all of you? Yeah, so a whopping 62% says, yes, we do need that label still, but only in combination with the individual assessment. So that nicely ties in with the previous question. Let's see. Anybody care to elaborate on this? Lev.
I'll pick up on Lenny's point, because I have strong feelings about this. Where, again, the European Directive on Victims' Rights really try to elaborate what we mean by vulnerability, because this has been the problem, is that when we say vulnerable, we don't actually say vulnerable to what, and what it tends to result in at the member state level is that there are about 3 or 4 groups of victims who, and that would be domestic violence or gender-based violence, child victims, human trafficking. So there are these certain groups which are automatically, they're the vulnerable ones. And the consequence of that has been that everyone else falls outside of that category, and any major advancements have been prioritized for those groups, and the other groups haven't really seen the same level of advancements. And I think it's not the right way of thinking. You should be understanding what are the vulnerabilities that you're trying to address, and develop systems that can identify people with those vulnerabilities and people with those needs, and develop an adaptive system accordingly. Now, you may have some shortcuts which helps you, and you may be able to say, okay, we're going to have a general assumption children are vulnerable and need certain things. But even that should be flexible, because maybe a 17-year-old wants to actually stand up in court and look the defendant in the eyes and tell him what happened and how he feels, and he should be given that, or she should be given that opportunity. So I think that for me is the starting point on vulnerability, is to not allow it to be a label which is only applied in a limited number of situations, but is used as a system to genuinely identify who is most in need, and to help us make some decisions about the use of scarce resources, so that those who have the most need get the things which they need.
Okay, thank you. Now, with an eye on the time, if I'm correct, this is the end of the panel session. And I think we could have gone on for another hour. We had some spare questions still. Many of those have been addressed or will be addressed in future conferences. Can I thank everybody, the members of the panel, of the audience, the organization, for your willingness to participate and to be so interactive. Thank you.
Thank you so much, Suzanne, and everyone else. And thank you for all the speakers as well, and for the interventions. Thank you to everyone in the chat for really being active. I think this has been successful, maybe even more successful than a live interactive debate, to be honest, because we've had both the chat in the messages as well as verbally. I will now hand over to our Vice President, Petra Klein, who's going to close the conference today. So over to you, Petra.
Thank you, Lev. Honored guests, on behalf of all the conference organizers who made an extraordinary job with regard to the pandemic situation to put the whole conference online only in 4 days. It is indeed my pleasure to make a few closing remarks and express gratitude to all those who made these events reality. This year, Victim Support Europe has offered a unique opportunity of varied group of speakers, from victims who gave impressive evidence today to policymakers, academics, and practitioners, to provide a comprehensive analysis of the importance of intersectoral cooperation to develop and maintain a comprehensive justice system that is less harmful to victims and victims' families. Today's discussions emphasize the role all sectors of society must play in supporting victims of crime throughout criminal justice proceedings. These examples help to highlight how essential it is to collaborate. By working together, agencies can provide services that are more efficient and effective than they would have been if those agencies acted alone. The advantages this offers in relation to viable criminal justice partnerships are varied and clear. From bringing together different perspectives on complex problems to ensuring a mutual beneficial understanding to cost savings through more efficient work methods, all should ultimately result in a more joined up and effective criminal justice system, which is better able to focus on justice for the victims and their families. We hear of good practices and alternative solutions. Our job is to expand on these practices, to increase our knowledge, and to disseminate what we learn across our countries and professions. During 2022, VSE will work explicitly to clarify laws, policies, and practices to better support the victims we represent. And we will look to raise public, professional, government, and victim awareness of the work being carried out to provide victims with access to safe justice at their time of need. We look forward to continuing this work in direct collaboration with you. I would like to thank you all once more for your active participation in this conference. I hope it has been informative and inspirational, and that you will be motivated to continue your work in supporting victims of crime. I certainly will. Thank you, everyone.